कितें म्हणले तुमी
स्पॉन्ज करपाक स्पीकर सर
नाही ओश शब्द बी आसा न्ही ते काडून उडय बरोबर न्ही गोंय पंचायत राज दुरुस्ती विधेयक 2023 पंचायत मंत्री विधेयक विचारांत घेवपाचो प्रस्ताव मांडचो
Sir, I move that Bill number 7 of Goa Panchayati Raj Amendment Bill 2023 be taken into consideration.
प्रश्न असो आसा विधेयक विचारांत घेवचें जांकां तें मान्य आसा ताणें हय म्हणचें जांकां मान्य ना ताणें ना म्हणचें हय म्हणटाचें म्हणणें मान्य जालें हय म्हणटाचें म्हणणें मान्य जालें आं उलयता तुवें
हय तर
आं येस उलय उलय बाल उलय सांग तूं.
बिल बिल
येस येस
पयलीं उठनाका रे स्पीकर सर
ये
हे बिला बरोबर मागीर हांवें हावजान स्टेटमेंट ऑफ ऑब्जेक्ट्स एंड रिजन सर्क्युलेट केला सो सारकी समजणी सगळे आमचे मान्य मेंबरांनी घेवचे म्हूण सो टू मेक इट व्हेरी क्लियर बिकॉज ओरिजिनल प्रिंट केला तेजे ते मीन्स व्हेरी क्लियरली इट वॉज नॉट डिफायन्ड दो एवरीथींग वॉज डिफायन्ड अंडरस्टूड न्ही
येस
जाल्यार वाचता क्लॉज नंबर 1 ऑफ सेक्शन 47 of the Goa Panchayati Raj Act 1994, Goa Act number 14 deals with the executive powers and functions of the Secretary of Village Panchayat in connection with the issue of license for construction and occupancy. Section 68, 69, 70 and 71 of the Goa Panchayati Raj Act 1994 provides for obtaining of license permission to carry out any trade, business or any other commercial activity within the jurisdiction of the VP. Generally, all licenses, permissions are issued by VP Secretary in pursuance of the resolution passed by the Panchayat. However, the existing subclause 1 of Section 47 is ambiguous and it has not been specified as to who is the competent authority to issue license permission in respect of any trade, business, commercial activity. In the absence of clarity in of Section 47, the said powers are at times by Sarpanch in terms of subclause 2 of Section 47A. By the proposed amendment to Section 47, the authority is specified in respect of provisions of issuance of license permission covered under the ambit of Section 68, 69, 70 and 71 to a single authority, that is Village Panchayat Secretary, in pursuance of the resolution of the Panchayat or pursuant to the order issued by the BDO or under deeming provision accrued by the applicant under Section 66, 68, 69, 70 and 71 of the Act. The existing provisions under 66(2) of the Goa Panchayati Raj Act 1994 makes it necessary for the applicant to file an appeal to the Deputy Director, which was a normal procedure, if the Panchayat does not within 30 days from the date of receipt of application determine whether such permission should be given or not and communicates its decision to the applicant. By the proposed amendment, the burden of filing an appeal to the Deputy Director is done away with. After 30 days of application, if the same has not been decided by the Panchayat, the power of the Panchayat to decide the same thereafter closes and the application shall be moved to the BDO by the Village Panchayat Secretary. The BDO shall thereafter assume the powers of the Panchayat and decide the application accordingly. The deeming provision in Section 66(2) is ambiguous. There is no clarity on how to proceed with the work on accrual of the deeming rights by the applicant. It also does not mention about payment of the construction license fee. There is also no mention of how to obtain the completion certificate and occupancy certificate. The existing provisions do not clarify the procedure for obtaining occupancy certificate on completion of the construction of the building. The proposed amendments provides for the same. The amendments proposed to Section 66(2) attempt to redress all these issues and are aimed at creating transparent and efficient machinery to streamline grant of construction licenses, occupancy certificates in pursuance of resolution of Panchayat or pursuant to the order issued by the BDO or under deeming provision accrued by the applicant under Section 66 of the Act. Further, subsection 2 of Section 68 of the Goa Panchayati Raj Act 1994 provides that the provisions of subsections 2, 3, 4, 5 and 6 An explanation to section 66 of the Act shall apply mutandis to section 68(1), which deals with the permissions to construct or establish any factory, workshop or workplace. As the amendments proposed in this bill to section 66(2) would bear relevance to subsection 2 of section 68, the same is proposed to be amended to give effect to the provisions of the proposed amendments. Section 72(2) of the Goa Panchayati Raj Act 1994 makes it mandatory for the applicant to file an appeal to the director if a panchayat fails to grant a license under section 69, 70 and 71 within 30 days from the date of communication of such order to the applicant. By the proposed amendment, it is proposed to ease the burden of the applicant, which is the common people, of filing an appeal before the director if the same has not been decided by the panchayat. By the proposed amendments, the application will be moved to the block development officer by the village panchayat secretary on completion of 30 days, and the block development officer shall thereafter assume the powers of the panchayat and decide the application accordingly. The amendments proposed to section 72 attempt to redress all these issues and are aimed at creating transparent and efficient machinery to streamline the process of grant of permissions, licenses under section 69, 70 and 71 in pursuance of resolution of panchayat or pursuant to the order issued by the BDO or under deeming provisions accrued by the applicant under section 68, 69, 70 and 71 of the Act. The bill seeks to achieve the above objective. हे मुद्दम आहे स्टेटमेंट एंड ऑब्जेक्ट वाचला आणि डिटेल सांगला दाखोवपाक कशें आमी ट्रान्सपरन्सी हाडपा सोदता ते. आतां प्रोसिजर कितें आसलें, एकदा कोण पंचायती वयता कसलेंय काम आसूं दी, एक एप्लिकेशन करता, थोडे ते मिटींग हाडनासले, रेजोल्युशन घेनासले आनी देर वॉज नो रेमेडी. Remedy was there to go before deputy director, hearing date after date. Podon, deputy director instead of grappling with the other work before them, your cases get alle. And your cases given, much of the relief ek applicant jai, tuja ek panchayat member against asle or kona naka jale jaina asle. Means there was no transparency in the functioning. By bringing about the amendment, ami simple thing kela. जे डेप्युटी डायरेक्टर वयताले 30 दिसान तरी डिसायड जायना, सेक्रेटरी डिसायड जायना, पंचायत डिसायड, बॉडी डिसायड करना जाल्यार सेक्रेटरी बीडीओ धाडटलो. बीडीओ विल सी द मेरिट. विदिन 30 days बीडीओ विल डिसायड एंड सेंड इट एंड ही विल अस्यूम द पावर्स एंड ही विल गिव द डिसिजन. जे डेप्युटी डायरेक्टर करतालो ते बीडीओ करता. सो इट इज एट अ मच लोअर लेवल. इट इज devolution of power rather at a lower level. We are giving away the powers what higher authority was trying to exercise. And आमी काय बदल हाडूना. If you look at the Goa Panchayati Raj Act 1994, it is the same thing is there under 66(2). The same thing is there that it goes before the deputy director. If the panchayat does not within 30 days receipt of application determine whether such permission should be given or not and communicate decision to the applicant may file an appeal before 30 days from the date of expiry of aforesaid period to the deputy director, who shall dispose of the same within 30 days of filing such an appeal. If the deputy director fails to dispose of the appeal within 30 days, such permission shall be deemed to have been given and the applicant may proceed to execute the work, but not so as to contravene any provisions of this act or any rules, bylaws made under this act. आता हे प्रोविजन हांव कित्याक मुद्दम वाचून दाखयला, हे ऑलरेडी आसले पूण इम्प्लिमेंट जायनासले. डीम प्रोविजन आसले, कशें इम्प्लिमेंट करपाचें, प्रॅक्टिकली कशें फोलपाचें, देर वॉज सम एम्बिग्युटी. वी हॅव सिम्प्लिफायड द होल थिंग सो दॅट द कॉमन मॅन जो पंचायती वयता, कितें एप्लिकेशन दिता, परमिशन जाता, सिम्प्लिफाय जालें. इतलेंच आमी केल्लें आसा बाय दीस अमेंडमेंट. वी विल सी हाव दीस थिंग वर्क्स एंड in due course of time it is expected to work even better. This particular provision or amendments which we are bringing were very much necessary. Ultimately, we are going to go digital in the entire process of functioning. Hunche application panchayati yata amche dashboard even we director of panchayat येवपा जाय की hunche दिसा hunche application येला, कितले दीस उरले, कितें डिसिजन घेयला, आमकां ट्रान्सपरंटली कळटलें. तें करतलें जाल्यार हे अमेंडमेंट हाडपाची सारकी गरज आसा म्हणून अमेंडमेंट हाडलेलो आसा आणि तुमच्या आणि तेज्यावन भायर सूचना सजेशन येयले ऑफकोर्स you will not move an amendment, but in due course of time I will make the correction, because ultimately I want to bring transparency, Speaker sir, in the functioning of the panchayats and see that things move faster in terms of development, in terms of permission, in terms of the functioning of the panchayats itself.
Speaker sir, the purpose of getting this amendment, the minister has explained, the focus is on transparency and efficiency. He wants to create a transparent and efficient mechanism to streamline the process of grant of permissions, licenses and occupancy certificates. Speaker sir, it appears the minister is trying to infer that the panchayats delay in making decisions on applications, which is why this amendment is sought to be brought. If so, there is a time-bound Delivery Services Act. Why that act is unable to address this issue? Why we have to have a separate act to ensure that services like construction licenses are provided on time? Has the government done any study to identify the reason for the delay? Are the applications not being put up in the meeting? Does it take time to inspect? Are files kept on hold for seeking bribes? If they are, how does the government know that the BDO will process the application in 30 days? BDOs are also overloaded with work. The act could be useful if there are hundreds of cases where applications are delayed. Common man, as the minister tried to say. But to tackle these hundreds of cases, can the BDO have time? Does the government have time to appoint additional BDOs? Or will the BDO give licenses sitting in the office without a site visit? Speaker sir, it must be noted that TCP only looks into building regulations within the plot. Panchayat is responsible for checking whether water paths are not blocked. Public utilities are available. Constructions like mega projects do not become a burden on the village. This is why village panchayats have a say in granting and rejecting applications. Speaker sir, for certain projects like lodging, restaurants, hotels, deliberation in the village becomes and site visits become important. Speaker sir, it is better that all these issues with the project are addressed in the panchayat and gram sabha rather than license be granted, work starts, money invested, and then panchayat revokes the license. It would cause a loss to the investor. Issue of transparency, I think, is related to the manner in which the government fights corruption. If villages are not transparent, if they take bribes, then is the government saying that BDOs are transparent and they won't take bribes? Speaker sir, if there is corruption and you want transparency, the bill, according to me, makes the process more opaque, not transparent. At least in panchayat, people will know which punch member is doing what is he seeking. And once file goes to the BDO, the Gram Sabha members will know what is going on. The issue is very clear that the government does not want to fight corruption in local bodies. On the contrary, the government wants to centralize corruption and make a single window for corruption through the BDO. Speaker sir, I think the way to handle this is that every 3 months, the secretary needs to send a report to the vigilance department on how many applications are pending, why they are pending. If files are pending and there is no justification, you take action against the punch members, including order a probe, impose fines of thousands of rupees on the panchayat, and money is given to the applicants who are suffering. Once punch members face action, automatically files will be approved on time. This is what we feel is the recourse to action available within available laws, within the existing laws. There is no need of this amendment. This amendment will kill governance at the local self-government body, which I agree with the honorable opposition leader. It was a historic amendment, the constitutional amendment, 73rd constitutional amendment, which is sought to be murdered by bringing this type of amendments here in the House.
Speaker sir, wait, let me reply to him. So that you have something beyond that, you can ask.
Why don't you reply to all at one time?
No, I would prefer, because he has covered almost everything.
Because you have other speakers waiting.
No, he has asked so many questions. No, listen, I will answer you. I will answer you. Okay. Speaker sir, the first thing is, the Honorable Member Shri Vijay Sardesai has not tried to understand. I have purposely, on purpose, given a very detailed statement of objects and reason. And I have also read what was previously there. What was the previous procedure? 66(2). If permission is not granted or application is not considered, the simple thing that the remedy that was available, this is already existing. We go before the deputy director. It becomes like a process. Hearing takes place. Months and months go. And then most cases, 90% of the cases, they used to give direction to issue the particular permission. So it was I would say, he had to hire a lawyer, the common applicant. He had to waste his time going 100 times. This same procedure is being followed. We are not altering or taking away anybody's powers. We are not empowering the BDOs per se. What was there before deputy director, we are giving it at a lower level. It will be much easier for the panchayat afterwards to access and work alongside the BDO. So rather we are simplifying the thing. Where is the question of government trying to usurp the powers? Already the provision was very much there, operating in the same manner. Only the authority was the deputy director. Deputy director has other responsibilities. And I have said, I have gone a step further. I said, later on, we are going to see that everything is going to go digital in the shortest possible time. I am trying my best. And everything will be on the dashboard. So there is no question of usurping powers. And what he is trying to tell is that we are trying to take this take. Nothing is altered whatsoever. We are absolutely within the Panchayati Raj Act, absolutely within the parameters what we were already functioning. Under the Panchayati sections, whatever are there, nothing is being altered. Please go through it carefully. That is what I want to mention to him.
Sir, I am standing to oppose the government's bill number 7 of 2023, bill to amend the Panchayat Raj Act to empower the secretary further. This bill proposes to further empower the Panchayat secretary and the BDO to take decisions. The bill is unlawful because the Panchayat Raj Act embodies the 73rd constitutional amendment and the Panchayat is a unit of self-government. The executive cannot be granted powers by usurping the powers of the government. The proposal under the bill to give powers to the secretary and the BDO to decide matters related to village development are unconstitutional. For example, the amendment of section 66 to allow BDO to decide whether construction permissions can be granted or not is grossly unlawful and untenable. Since the BDO is in no position to decide on this matter, which involves village development, unsustainability, local issues, and other rights of local communities, including access, grazing, cultivation, water resources, and environment. My second point is the past amendments of the law diluting the powers of the panchayats are all unconstitutional, and the bill should be restoring the powers of the panchayat rather than further diluting them. All construction proposals must be first reviewed by the panchayats for sustainability and feasibility, not the TCP, which is only a technical body. Similarly, past amendments empowering the executive, like the secretary or BDO, at the cost of local government and democracy, must be dropped through suitable amendments. I would like to produce this in the floor of the House, and as I oppose this bill, I would like to request you, let us go for a vote. Let us go for a vote of division, for a division of votes on this particular bill. Thanks, Speaker.
Speaker, sir, I don't find a single point which is something new from what Honorable Shri Vijay Sardesai has said.
Answer once and for all at the end, no?
No, that's why I'm saying no. I purposely want to see who is making some new point. Simple thing it is, the same thing from Deputy Director is moving to this, to the BDO. And where there is question of usurping of power or removing the power, which act change केला किती बदल आणला दाखवे मध्ये.
Advocate Carlos, please start.
जे सरपंच आदला ते आम्ही काढला.
You want me to reply? I'm going to reply. If you're questioning me, then I've already given. Because village matters BDO is a very lower level
Honorable
bureaucrat.
member, there is a member on his feet already. Please.
I oppose this amendment because though it may seem very good, but what is happening is it is actually robbing the panchayats of the constitutional rights conferred by Part 9 of the Constitution. And I will point out why. The earlier provision provided, as the Honourable Minister correctly said, that if an application under Section 66 was not decided within 30 days, an appeal would lie to the Deputy Director. Now, you are not only providing that same forum of appeal, but the forum is made a BDO, the right of appeal is given, but here you are taking out the file. Please see this, what is happening. The Secretary shall forward the application to the Block Development Officer. That means he will physically take this file out from the Panchayat and put it to the BDO. That means you are now depriving the Panchayat of taking any action once that file goes out. This danger is because no Panchayat can take decisions immediately. They have to call for inspection, they may have to consider objections, it may have to go to Gram Sabha. So you are taking the file away and the Panchayat will have to say, we have nothing before it, file has gone to the BDO now. Has any study been done as to the number of cases which are pending before the Deputy Director? How many years they're pending and the reasons for the pendency? Has this study been made so as to justify that the Deputy Director is overburdened? Because simply passing the buck from Peter to Paul does not serve any purpose. You're only passing it from one forum to another. The Honourable Minister also said, we are reducing the burden of the common man to avoid an appeal. The BDO sits in the same building where the Deputy Director sits. There's nothing different. Now, have you removed the provision of appeal? The answer is no. The Secretary shall forward the application to the Block Development Officer on expiry of such period of 30 days, and the applicant may also file an appeal within a period of 30 days. So you're giving both the options. So which will happen? It will confuse. And then finally, if the BDO does not decide within 30 days, it is deemed to be granted. Now what would happen is, there can be manner in which you can get the BDO to take a decision or to refrain from taking a decision, which means you have actually taken away the Panchayat powers. If the Deputy Director is overburdened, then I can't see why the BDOs are also not equally overburdened. They also have got many other functions under the statute. There is one point which I want to make very clearly. Under Section 66, end of Section 66, there is an explanation. The Section 66(2), as it stood, required the Panchayat to take a decision within 30 days. If not, an appeal was available. Now, why I told about 66(2), please listen to these words. Explanation. For the purpose of this section, failure to communicate the decision by the Panchayat under subsection 2, that's the same one, 30 days, and failure to demolish the building, we are not concerned, shall be deemed to be remiss in the performance of the duties by the Panchayat. That means you can take the Panchayat to task and dismiss the body for remiss if it fails to take a decision. You are not providing a solace here, you are providing additional burden and taking away. It's like by giving us a sweet laced with poison, you are killing the Panchayat. So I am opposing this amendment.
Because, sir, I am surprised my learned friend, who otherwise understands law clearly, is trying to sort of explain it in altogether different way. We have not transgressed from the main policy and the main remedy which was available to any applicant. What was the remedy, as I am again repeating? Go before the Deputy Director in appeal. Your case goes on. Poor man is burdened, or the applicant is burdened for months or years together to get the decision. Afterwards, again it goes, and practically something else only happens in the panchayats. We have simplified that and taken it to the BDO. And if a government is empowered to get an amendment towards this, we will see how it works. If it does not work, if there are, as you say, there will be problems, we can again come to the house with even a better remedy and a better amendment. Nothing is permanent. We are only trying to streamline something which is already there, available under 66(2), and trying to make it even better for the common man. Please try to understand that.
Speaker, sir, the minister is very strongly advocating his case. And he is talking about efficiency and trying to make it clean, no corruption. I remember that when the panchayat elections were held, there was a pendal put outside Honorable Chief Minister's house. And all the panches who won were brought there and they photographed themselves with the Chief Minister and the local MLA. And I presume these panches belong to the ruling party, the BJP. Is the minister trying to tell the house that panchas of the BJP are corrupt and that they are seeking bribes for licenses, occupancy and other permissions. Does he have to bring this amendment, especially because his local bodies are infested with corrupt karyakartas? What is the problem? Please explain.
I think you have already covered this point when you spoke.
Because, sir,
I'm-
again,
Honorable Minister, let us move
Mr.
ahead.
Vijay Sardesai is using the word corruption. He is alleging there is corruption and trying to
let us
take some of my
move ahead.
surpluses. I have not said a word on that. I am not even
No,
suggesting.
in your
I am only
objects,
suggesting
in your objects, you are
that
talking
I
of
am trying to
transparency and
improve a
efficiency.
system which is already existing by getting a good amendment.
I
That's
would
all.
suggest let us move
Why are you
ahead.
attributing motives and attributing motives to the Sarpanchis also?
I'm putting it to the vote of the House. I'm putting it
No,
before the
Speaker,
House.
sir, division.
We request for a division.
अरे ताणे वोटिंगाक घालता म्हणल्यार
Okay. We'll put.
म्हणलें मरे ताणे आय एम पुटिंग इट टू द वोट ऑफ द हाऊस म्हणून आनी केन्ना रावन जातकर मागीर याद करता
Those in favors,
तुवें तें
please stand up. In favor of the bill, please stand up.
बीजेपी पंच करप्ट म्हणून उबे रावल्या तुमी
तूच म्हणटा मरे.
हांव पंच करप्ट म्हणपा आहा
We'll move on. Those against, the ayes have it. The ayes have it. The motion for consideration of the bill has been adopted. I shall now submit the bill to the House clause by clause. There are no amendments to the bill. The question is that clauses 2 to 5, clause 1, the enacting formula and the long title do stand part of the bill. Those in favor may say aye and those against may say no. The ayes have it. The ayes have it. Clauses 2 to 5, clause 1, the enacting formula and the long title do stand part of the bill. The Minister for Panchayats may now move the bill for passing of the bill. May now move the motion, sorry.
Speaker, sir, I move that Bill number 7, the Goa Panchayati Raj Amendment Bill 2023 be passed.
The question is that the bill be passed. Those in favor may say aye and those against may say no. Ayes have it. Ayes have it. The Goa Panchayat Raj Amendment Bill 2023 has been passed. Minister for Revenue may move the motion for consideration of the bill, the Goa Land Revenue Code Amendment Bill 2023.
Speaker, sir, I request to move that Bill number 9 of 2023, the Goa Land Revenue Code Amendment Bill 2023, to be taken into consideration.
The question is that the bill may be taken into consideration.
Speaker, sir, what is that? Yeah. Speaker, sir, considering the importance of stone crushers towards development of infrastructure in the state of Goa, in the past had issued an order number 14/11/2008 RD, dated 2/3/2009, thereby exempting the stone crushers retrospectively from obtaining conversion sanad. However, the above order was challenged before the Honorable High Court of Bombay in Goa in writ petition number 613/2009. The High Court, via order and judgment dated 17/11/2021, set aside the said order, stating that under Section 32, which is exempted in a class of land and not an activity. By the present amendment, considering the importance and useful contribution in infrastructure development of the state government wants to protect the stone crushers unit, which are operating with all valid permission registration obtained from the Directorate of Mines and Geology, Director of Industries, Trade and Commerce, as on 31/12/2007, and exempt them from provisions of Section 30 of the Land Revenue Code. Further, the state government will receive adequate revenue from the above activity. The Revenue Department will charge rupees 100 per square meter of such land per annum for a period of 10 years from the date of issuance of such registration, permission by the Director of Mines and Geology, Director of Industries, Trade and Commerce, and thereafter at the rate increased by 50% of the rate of land revenue last payable after every 10 years.
Yes, you know. Kabul.
Speaker sir,
Yes.
the minister has said that there is a need to exempt crushers and basalt quarries for conversion fees. Now, how many quarry and crusher licenses does the government want to issue? What is the area that will be covered? What will be the finance implications on the state by waiving the conversion fees? I think the bill says that the finance implications are involved and they cannot be quantified. Why they can't be quantified? That's the question. Because the government must have received complaints or has some record of quarries and crushers without sanad. Someone must have come to the government asking to waive the sanad conversion fees for basalt crusher. Does the calculation of sanad conversion fees of these existing sites exist? If the government has no record, that means this is not a real issue, which means there is no need to bring the bill to the House. Speaker sir, my question is, how will the government know if the part of the land is agriculture or no development zone, or if there is encroachment on some neighboring land? The benefit of sanad conversion is that all these issues are brought on record. So if there is any illegality, the affected person can apply under RTI and check whether permissions have been taken. This bill is going to spell disaster for eco-sensitive areas, especially hills and plateaus. कोणी खंय वता थंय खणपाक लागतलो in remote areas. Speaker sir, if people want to complain against any suspected illegal quarry or crusher, the panchayat and the collector are the first two departments which people approach. अशें धरया एक सांग्या क्वॉरी आहा, इल्लिगॅलिटी करता, जाल्यार ते मायन्स डिपार्टमेंटा कडेन पणजे येवचे नात, ते वतले पंचायती कडेन नाल्यार डेप्युटी कलेक्टरा कडेन. डेप्युटी कलेक्टरान स्टॉप वर्क ऑर्डर करूंक जाता इल्लिगल लँड कन्वर्जनाक. गव्हर्नमेंट हें ऑप्शन कित्याक सिटिजना कडच्यान काडून घेवंक सोदता ते म्हाका दिसता मंत्र्यान मातशें एक्सप्लेन करूंक जाय.
फक्त हांव एकूच ऍड करता ताका, मागीर लेट रेव्हेन्यू मिनिस्टर स्पीक्स. 146 क्रशर युनिट्स आर प्रेजेंटली वर्किंग आनी ते बी 2007च्या पयलीं जे रजिस्टर्ड आसा 2007च्या पयलीं तांकां क्वॉरी मार्क करून दिल्ली आसा पळय न्ही, तांच्या खातीर म्हाका हे 146 हे गोंयकार ना जाल्यार जातलें कितें? परत तुमीच म्हणटाले तेंचे क्रशर बंद उडयले आनी आतां भायल्यान खडी हाडपाक लागले.
फायनान्स इम्प्लिकेशन बिलान म्हणलां ऑब्जेक्शन की फायनान्स इम्प्लिकेशन आसात, बट द सेम कॉन्ट बी क्वॉन्टिफायड म्हणून. तूं जर नंबर जाणा जाल्यार तुका फायनान्स इम्प्लिकेशनूय खबर आसतलें.
स्पीकर
सर, जे
देव
तुवें आतां उल्लेख केल्लो की तितून 140 गोंयकार आहाय जे क्रशर युनिटाचे, तितून 140 तुला एकलोय मनीस आहा जो क्रशर हें चलयता गव्हर्मेंट लँडाचे ग्रॅब करून, लँड ग्रॅबिंग, तुका खबर आहा तें. सो स्पीकर सर
हांव क्लॅरिफाय करता, हो मुद्दो पयलीं क्लॅरिफाय करता. स्पीकर सर 2007 पयलीं ही लिजां दिल्ली, गव्हर्मेंट लँडाचेर सुद्दां जर दिल्ले आसत जाल्यार 2007 पयलीं ताका दिलां, ग्रॅब करूंक ना, आनी ग्रॅब करूंक आमी कोणाक दिना. And the area
Speaker sir, this issue had come up last time as well in the last assembly. I just want to tell you, Honorable Chief Minister, I will give it to you in person. The name 3,510 square meters of government land has been grabbed. Anyway, Speaker sir, while speaking on this bill, I would request the Honorable Minister that he should suggest that the area, there's no mention of the area of such regularized cases must be specified as on date.
As per the lease.
I have got a list of areas basically in different talukas.
No, Honorable Minister in the object has said that he can't quantify the finance implications. Because the finance implication कशें येता, जमनीची एरिया आनी सनद फीज. आता जमनीची एरिया जर तुका खबर आहा जाल्यार सनद फी कॅल्क्युलेट कर मरे, इतले ऑफिसर बसल्या तुजे. मेळ्ळें तुका फायनान्स इम्प्लिकेशन हय तो प्रॉब्लेम हो जाता फाल्यां आमचो इश्यू आसा की एक प्रायव्हेट जमनीचेर तूं खणपाक गेलो हांव क्रशर ओनर पूण
स्पीकर सर नवीन आमी अलाव करिना हितूर म्हटलेलें आसा
एक्झिस्टिंग इश्यूज आहा न्ही ताणें सांगलें तुका एक
न्ही पूण तेंय सांगलें तुका हांवें 2007च्या पयलीं जी लिजीस दिल्ली त्यांचोच विशय आसा हो
2007ची सगळ्यो लिगल आहा
2007 पयलीं ज्यो मायन्स डिपार्टमेंटान लिगल दिल्ल्यो त्यो आसा ह्यो
तशें म्हणटा हांव तातूंत भितर डिस्प्यूट ना
एरिया एनमार्क आसा
ना ना ना
एरियन डिस्प्यूट ना
गव्हर्नमेंटाची जमनीचेर तिसरो करता अशें ना
that is on working on water resources department land
बसून घे
ना स्पीकर सर जो सांगता पळय ते there is a particular land 3510 square meters of water resources department
येस प्रश्न असो आसा विधेयक विचारांत घेवचें जांकां तें मान्य आसा बस सांगा न्ही उलया मरे तुम्ही उलया मरे तुम्ही उलयता
पण लिस्टाचे नाव आहे ते मातशे 4-5 नाव आहे
उलय म्हणटी
I'll just finish. Just a small this thing. While this amendment is said to be in respect of those quarries which are operating before 2007 or as on 2007, can you see the section 30, the first amendment, proviso? It says, provided further that nothing in this section shall apply to the activity undertaken in pursuance of the permission license granted under this MMRD Act and rules made thereunder. Now please see this, and then on the next page, 30A, that speaks of 31st December 2007. I'm showing you this for the contrast. Now please see how 30 looks. The words are like this. Nothing in this section shall apply to the activity undertaken. Where is the word undertaken? Previously. That means you can even undertake it now. Your intention I can understand, but the wordings which I will tell you, if I am to argue this matter and I'll tell you this undertaken previously is not there. If I put the word previously, the whole effect meaning change jata. Utar na zalyar, undertaking has an effect means, undertaken means you get the permission, you undertake it.
New permissions also can be given. Previously it is. This is previously.
Where is the word previously? That is where it is. But no, even the minister thinks it can be taken now. Minister who sangta.
It is till 2007, 31st of December 2007.
That is different. That is condoning those. 30A is condoning, but this one is allowing new. Please look at 30.
Operating functioning is on the 31st day of December 2007.
No. Please look at 30. Section 2 amendment. Provided further that nothing in this section shall apply to the activity undertaken. Undertaken can be now undertaken also. Where is the word previously? You can add the word and do it. I have no problem. Otherwise, open jata.
No, the date are fixed.
Date na.
Operating functioning as on 31st of December asa.
No. That explanation is only for 30A.
Experience. Ulay.
30A is standalone. Standalone section. So the explanation is to the standalone.
Speaker sir, हेजे लागू म्हाका दिसता ही बिल मातशें बेगीन दिवपा जाय आमकां 48 hours होन तरी दिवपा जाय लास्ट एक
We are helping the government, we are not opposing. Only the thing is,
if the government is not aware, Speaker sir, this is
a chance घेवन सगळे कोतले मागीर.
कोणाकूय चान्स पडटलो
हे सिलेक्ट कमिटी धाडचे ना जाल्यार स्पीकर सर माहिती ना जाल्यार
स्पीकर सर
उलय मरे
स्पीकर सर गोवा लँड रेव्हन्यू कोड अमेंडमेंट हांवें बरे भशेन वाचलां आतां सांगलां ते भशेन मिस्टेक हें पास जालें जाल्यार आमकां खूब माल पडटलें आनी हें 1968 जाल्लें तेच फाटल्यान जायते चीफ मिनिस्टर जाल्ले मिनिस्टराक कोणेंच अमेंडमेंट केलो ना ताचो कॉन्सिक्वन्सीस कितें जावपा ते सगळे जाणात आनी भोव करून हांव सांगता आमचे सांजे दे आर मोर दॅन 100 क्रशर्स आहाय आतां हांव नोका 140 दिला ते मोर दॅन 100 क्रशर्स आहाय आनी सालजारा आनी सांजे दे आर जरी तर आनीकय परमिशनां मेळ्ळी जाल्यार सांजे दे आर आनी सालजारा गांव काबार जातलो सो हांव मागता हें बील सिलेक्ट कमिटी घालचें आनी हें आमचेर घेयच न्हू आनी हे फुडले कितें चेंजीस करून फुडले असेंब्ली सेशन आमी घेवचें म्हणून.
जशे आयज सगळे एमएलएनी ओपोज केल्लो आसा हे जो कायदो आसा आनी मिनिस्टरांनी सांगलेलें आसा की न्यू जी आसा तीय घेवपाक शकता. सो मिनिस्टरान मेन्शन केला. सो अशें जे डेंजरस बील आसा आयज तुम्ही पळयता आसतले एग्रीकल्चर लँड जावं खंय दोंगर आसा खंय खणपाक लागतले. फाल्यां परमिशन फक्त मायन डिपार्टमेंट कोण कंट्रोल करतलो. कारण पयलू कशें आसलें पयलू कलेक्टर कडेन पळोवपाक शकताले. सो आतां समज हें बील कायदो हाडलो जाल्यार सगळी एग्रीकल्चर जो एग्रीकल्चर जमीन आसा कोणाक समज दिसते प्रायवेट प्रॉपर्टी आसा आनी ते प्रायवेट प्रॉपर्टी आपल्याक खण करपाक जाय. चिऱ्यांची खण करपाक जाय जावं आनी कितें खणपाक जाय मायनिंग स्टार्ट करपाक जाय. सो तो जाय तशी करूं शकतलो. फक्त मायनिंग डिपार्टमेंटाची परमिशन आसा. हांगा कलेक्टर लँड यूज सगळो चेंज जातलो. समज एग्रीकल्चर लँड आसा दोनूय सायडीन दोंगर आसा त्या दोंगरा मदीं एक दोंगर हाडलो आनी तो कट केलो नाल्यार सगळे सायडीचे जे दोंगर आसा तांकां सगळ्यांक प्रॉब्लेम जातली. सो मागता आनी आमी ओपोज करता एज अ ऑपोजिशन सगळे ओपोज करता हो बील फाटीं घेवचो म्हणून.
हे दाखयता आसतना म्हणजे खूब मोठे कितें दाखयता. परत एकदां सांगता म्हणजे पयले बील हे जे आहा पळय न्ही ते क्रशरा खातीर आसा. क्रशराचो लँड युजा खातीर आसा. ओके वीच इज क्लियर. म्हणजे तितूर जे हय आनी इवन दो एक क्रशरा खातीर आसा. सो दॅट एंड सेकंड जो यूज म्हटला पळय न्ही तेणी ओके इट इज टील 31 डिसेंबर 2007 हेच्या पयलींच्या युजांतलो आसा. विशय तितको क्लियर आसा स्पीकर सर.
नेक्स्ट वेंजी.
आनी इवन दो अकॉर्डिंग टू द MMDR Act 2015 आतांय बी तशें पळोवंक वचत जाल्यार कन्वर्जन चार्जीस जे आसा MMDR एक्टाच्या नुसार घेयना स्पीकर सर इन लीज एरिया.
वेंजी वेगस.
Okay, Speaker Sir, I stand to oppose the government bill number 23, bill to make exemptions to conversion requirements under LRC. The bill proposes to make exemptions to the requirement to obtain conversion sannads for mining activities and for basalt stone crushers. The bill is unlawful because what we have brought in an amendment is 30A, an independent section under Amendment 30. The requirements of Section 30 are applicable to all activities and the exemption made for mining activities cannot be sustained. This will lead to unrestricted mining activities across the state, devastating the environment and the scarce of water resources of Goa. Second, the government has earlier tried to use Section 35 of LRC to allow stone crusher units to operate without conversion sannads, which was struck down by the High Court. The stone crusher units operating without conversion sannads across the state were to be stopped and demolished according to the High Court's orders. But government has protected the illegalities by not acting till date. The proposed amendment to allow stone crusher unit to operate without conversion sannads is completely illegal and is a blatant attempt to overcome High Court orders and the law to aid illegal operators of crusher units who are destroying the environment. And my third point, the obvious inequality of the proposed exemptions for mining and crusher units is that poor, ordinary citizens, schools, hospitals and other socially important activities will be required to obtain conversion sannads even for their small requirements, while profit-making corporates will be given an exemption for the most destructive and unsustainable activity in the state. I would like to put this on the floor of the House. I would demand for a select committee and for a division of votes on this bill number 9, sir.
Speaker sir, 30A जो आहा पळय न्ही land used in relation with a certain basalt stone crusher unit हो म्हाका दिसता क्लियर कट वाचचो. तो क्लियर कट वाचीत जाल्यार ते बिल क्लियर जाता. स्पीकर सर हातूर क्लियर एक्सप्लेन केल्लें आसा. बिफोर 2007 चोय विशय क्लियर केला आनी ताज्या उपरांतचोय जो विशय आहा पळय न्ही तितूरय क्लियर केला. एप्रॉक्सिमेटली स्पीकर सर हातूंत जाय जाल्यार इट इज एन notwithstanding any constraining the code or any other law or the time being in force or any in contract judgment, decree or the order of any court of the law in any instrument and having the force of law, not the section 30 shall be applied and to the land use for the operational functioning to the basalt stone crusher unit and which was operating functioning on 31st day of December 2007 in pursuance of the valid permissions registration obtained from Director of Mines and Geology, Directorate of Industries, Trade and Commerce, and such basalt stone crushers unit shall be deemed to have been lawfully using such land for carrying on the operation on the basalt stone crushing subject to the condition of such basalt stone crushers unit pays pay to the government land revenue at the rate of rupees 100 per square meter of such land per annum for the period of 10 years from the date of the issuance and of such registration permission by the Director of Mines and Geology, Director of Industry, State of Commerce, and thereafter at the rate of increase by 50% of the rate of the land revenue last payable after every 10 years. Clear, Mr. Speaker, sir.
I just want to help the government, because I'm telling you what will happen is there will be applications which will ask you now for this, and they will use this clause. I'm going to show you why. Please look at your own bill. When you see clause 2, insertion of new section 30A. Can you see that? Insertion of new section. After section 30A, the principle, the following section shall be inserted. Now please look down. Explanation. For the purpose of this section, that means these words which you have explained, 31st December 2007, applies only for this section, which is 30A. It does not apply for the above one, proviso. That proviso will be opening the floodgates for anybody to get the benefit. That is what it is. So now that is it. You're saying yes, you're saying no. Which? Soglan Yupache? Just now the Honorable Chief Minister said no, it's 2007.
Section 30 is applicable for everyone, and you're introducing 30A.
30 Soglan
सिलेक्ट कमिटी घालया आणि परत रिवाइज करूया, हेची चर्चा करूया. सिलेक्ट कमिटी घालून सध्या होल्डार दवरया. And if there is a majority, it is bad in law.
एक मिनट. ऐकून घ्या.
Speaker sir, the bill has been written by the law ministry, and I will explain to you what it is a law subject. I will explain to you what it is, Speaker sir. Speaker sir, हे जे 330A जो आमचो advocate Carlos Bab सांगता, it is specific for exemption for that particular period which is mentioned and explanation has been given. By itself, all mining under MMDR Act, even major minerals which are there, this is minor minerals. Under MMDR Act, everybody is exempted from surface right conversion, which is already. Let me explain. This is what is being brought in this. This was already there.
With great respect, don't confuse surface rights under MMDR Act
with land for conversion.
If it's already covered, then you don't require this.
That is what is brought. No, it is under this Act, which is MMDR Act, which is there. You read it, sir. Speaker, sir, provided and further noting that in section shall be provided to activity undertaken in pursuance, the major act of 30 allows you to do it. So clarification of 30A is to bring it into existence for those people.
No mining, major or minor can be undertaken without license under MMRD Act.
Yeah, so MMDR after license only it is given.
Then you require conversion, Sanad.
No, Speaker, sir.
So you are removing this.
Issue how, Speaker,
understand.
Sir. Amendment to Section 30. In Section 30 of the Goa Land Revenue Code 1968, Act number 9 of the 1960, hereby referred to as the Principal Act. After existing provision, the following provision shall be inserted, namely, in the Major Act itself, we are bringing the provision in 30. Provided further that nothing in this section shall apply to the activities undertaken in pursuance of the permission/license granted under the Mines and Mineral Development and Regulation Act 1957, Central Act of 1967 or 1950 under rules on that matter. Therefore, so we are in this section. We are bringing the main section itself that everybody is exempted. In 30A, we are bringing this provision because there was an issue on the High Court where they are also covered, Speaker, sir.
See, what is happening? What is happening is for those of 2007, you are punishing them by giving them this such amount. And for those of now who will undertake, where is that 10 years and all that to be paid? This is only for those who have done before. 30A is to legalize those which were functioning illegally. Now, what about this 30? What will they pay? You are exempting them and they'll pay nothing.
Speaker, sir, because there was no clarity, that is why 30A is being brought. And 30A, that proviso is being made, which is very clear. As far as 30A, what he says is that exemption which is made is for those people who have met in the High Court. And that is why this provision has been made for 30A. Yes, he is added to that, Speaker, sir. What you are saying is correct.
There is no objection to that one. No objection to 30A. But my question is 30, the proviso will go across the board and give them a free run.
Speaker, sir, this is the Act. And if what he is saying, then the rules will be brought afterwards. Whatever he is saying, we will bring the rules for them.
Yes.
No, there's no reserve for select committee.
Next
Very
audience.
clear, Speaker.
पास करून रूल सरपंच स्पीकर सर
Speaker, sir, we'll
आम्ही
read the
रुल्सान पळयता विल सी इन द रुल्स
He is only saying it is going to be brought up, so bring it under select committee. Why is the hurry to pass it out now? Kida take da? Are? You are going to put complications.
Sir, whatever rules
This is
have
going
been
to make
framed,
people suffer.
the rules will be
You need
framed.
to amend section 30 rather than introducing 30A. You 30 amend करपा जाशिल्लें,
प्रश्न
तितू add करपा जालो
विधेयक
paragraph.
विचारान घेवचें
No, that 30 would have been a separate.
मान्य आसा ताणें हय म्हणचें
Speaker, sir, I request to
मान्य
move
ना
that.
ताणें ना म्हणचें हय म्हणटाचें म्हणणें मान्य जालें
But ये totally wrong.
एक विचारान
Because हे
घेवपाचो
तुकाय
प्रस्ताव
सारक न्ही.
मान्य जाला
गोंयकारा पासो ते तुकाय सारक
हांव
न्ही. सिलेक्ट
आतां
कमिटी
विधेयक कलमार सभागृहांत सादर करता विधेयकाक दुरुस्त्यो नात प्रश्न असो आसा कलम 2 कलम 1 अधिनियम सूत्र आनी प्रदीर्घ मथळ्याचो विधेयकाचो भाग जावचो काय कितें जेका मान्य आसा ताणें हय म्हणचें जेका मान्य ना ताणें ना म्हणचें हय म्हणटाचें म्हणणें मान्य जाला हय म्हणटाचें म्हणणें मान्य जाला कलम 2 कलम 1 अधिनियमन सूत्र आनी प्रदीर्घ मथळ्याचो विधेयकाचो भाग जाल्यात महसूल मंत्री आतां विधेयक मानून घेवपाचो प्रस्ताव मांडचो
Sir, I request to move that Bill number 9, 2023, the Goa Land Revenue Code Amendment Bill 2023 be passed.
प्रश्न असो आसा विधेयक मानून घेवचें जेका मान्य आसा ताणें हय म्हणचें जेका मान्य ना ताणें ना म्हणचें
We had asked for a division of vote. अजून तुम्ही division of vote गेल ना. We had asked for a demanded for a division of vote.
Yes.
Why do we have to repeat?
हय म्हणटलें हय म्हणटलें उबी रावत स्टँड अप
दोज आर इन फेवर
Asani pura. Asani pura.
जालें
मेस तू कितले जाता
27 अच्छा ना म्हणटलें उबी रावत स्टँड अप 1 2 3 4 5 6 7 7 हय म्हणटाचें 27 ना म्हणटाचें 7 येस हय म्हण मिनिस्टर हय म्हणटाचें म्हणणें मान्य जाला हय म्हणटाचें म्हणणें मान्य जाला गोंय विधिनियम वसूल कायदो विधेयक 2023 मान्य जाला भारतीय स्टॅम्प गोवा दुरुस्ती विधेयक 2023 रेव्हेन्यू मिनिस्टर
Speaker, sir, I request to move that Bill number 10 of 2023, the Indian Stamp Goa Amendment Bill 2023 be taken into consideration.
येस प्रश्न असो आसा विधेयक विचारान घेवचें जेका मान्य आसा ताणें हय म्हणचें जेका मान्य ना ताणें ना म्हणचें
Speaker, sir.
हय म्हणटाचें म्हणणें मान्य जाला
Speaker, sir.
Yes, okay.
This bill seeks to amend clause A of Article 32 of Schedule 1A to the Indian Stamp Act 1899, in bracket 2 of 1898, as in force in the state of Goa, so as to give benefit to of reduction in stamp duty leviable on instrument of gift executed in favor of brother-in-law or sister-in-law as well, and to encourage registration of more such instruments. This bill seeks to achieve this above objective.
Yes, Ulay.
Current Stamp Duty Act allows a person to gift to father, mother, brother, sister, wife, husband, daughter, son, grandson and granddaughter. Pairing the wife, which is a legal relation to the gift, rest are all blood relations. This amendment that the minister wants to bring is adding brother-in-law and sister-in-law, very specific. Now, which brother-in-law and sister-in-law has approached the government to bring this specific amendment? Because, sir, no, 1 minute, don't disturb me. I'm on my feet. Because, sir, अशी बिलां जी हाडटात ताजेर एक डावट येता की बाबा हे इतलें कितें ब्रदर इन लॉ म्हणटकच आतां आय एम जस्ट एक्सप्लेनिंग नाव. Speaker, sir, brother-in-law is not a blood relation. Brother-in-law can mean wife's brother or sister's husband. Which one is the bill referring to? Both. Okay. Now, if it is sister's husband, then there is no use of making a gift deed. Because if you gift your sister, her husband will get her half share automatically. If you give to your sister's husband, your sister will get the half share. So why bring the bill? One minute. Problem with gifting to your spouse's brother or sister is what will happen if you divorce your spouse. Gift दिला नाही तो divorce केली. माहिती किती करतो? No, one minute. सांगता मर तुका. What will she remain your sister-in-law or will he remain your brother-in-law? Will the gift remain valid? No, will the gift still remain valid? Speaker sir, these are matters of law. One should be able to gift assets to their daughters-in-law and sons-in-laws also. Why only brother-in-law and sister-in-law? Give to daughter-in-law and son-in-law also. And if brother-in-law and sister-in-law are added, why not nieces and nephews? I'll give you an example. An unmarried individual treats his nephew or niece as their own children. So why this relation should not be added? I'm unmarried. Mazo baso to mazo cholo ata. Ashi jata if I am unmarried. Speaker sir, ani ek practical issue जाऊं शकता. अशे धोरिया कि there is a couple without children and they are living in the husband's house as joint family. Speaker sir, यहाँ ऐकूचे हाँ मजे. Seriously, मुख्यमंत्र्यान ऐकूचे. उसली बिला हाडटा म्हणून. एक couple living in the husband's house as joint family. Husband dies and wife, who is a housewife with no income, has to stay with the mother-in-law and brother-in-law. There is no law protecting the right of the wife since husband's share goes back to the husband's family. This is a case in point today in the law. The in-laws can easily put her out of the house. ती विधवा झाली, ती उरली आता. I'm just telling you, listen man, don't talk first and I'm putting to you a case. You are a law minister, then give your judgment. Eventually you will say division and you will pass it. I know that. But I'm just giving you so that you are aware of the implications. Speaker sir, the in-laws can easily put this widow out of the house instead of supporting the wife. The only protection of the wife is what? If the wife dies. Because if she dies, then what happens? Her share will go to her family. So the wife at least has some leverage over her husband's family. Now with this law, the in-laws can force the wife to sign a gift deed, to give up a share. Police will not get involved because they'll say it is a civil matter. The widow can be mentally tortured to sign the gift deed and give up her rights. She can be forced to sign a will, but at least she retains her share of the house assets till she dies and can revoke the will if she is treated badly. So is there a limit to the amount of assets you can gift under this amendment? I think the bill has to be thought through and needs to be sent to a select committee because you all don't have any answers to all these questions that I've put. I've twisted it this way, that way. Brother-in-law, sister-in-law, पळय विचार करा हाजेर. तुम्ही हाडटा कोणचो तुका brother-in-law and sister-in-law तुमकां मेळा आनी कोणालो ते मातशें सांगात. येदे व्हडलो कायदो बदलूंक फुडें सरले ते.
You give a chance for your brother-in-law, sister-in-law also to
No. See,
in future.
Whatever I have said, you please consider this. I am not trying to make fun of you. I am putting to you an hypothetical situation. And I think you need to think this through. Law Minister has not even heard 1% of what I have said. Yes.
हांव फक्त एकूच सांगूंक सोदता विजय बाबान जी काणी सांगल्या ती काणी तेकाच बरी आहा. स्पीकर सर हांव सांगता स्पीकर सर तेणे पळय स्पीकर सर ब्रदर इन लॉ जे पळय सांगला पळय तेजे निसाक आनी नेफ्यूआक आनी म्हाका म्हज्या निसाक आनी नेफ्यूआक दिवपाक जाय. सो तेका आपणाच्या भावाक दिवं न्ही. नीस आनी नेफ्यू खंयच्या एक तरी भयणीची येता नाजाल्यार तेच्या भावाची येता. सो तेका कायद्या भितर तेका दिवपाक मेळटा. एक जालें. दुसरें ते सांगता पळय स्पीकर सर की आपणा एक खंय विधवा जाली बायल जाल्यार फोर्स करतले सायन मारपाक त्या सिट्युएशनाक लागून तो बिल फाटीं घे म्हणटा स्पीकर सर. म्हाका स्पीकर सर लॉ जर कोण हातीन घेता लॉ कोण हातीन घेता तो सांगता ते सारखे क्रिमिनल सिव्हिल मॅटर म्हणून सांगता ते सिव्हिल आसा. शी स्टील हॅज अ रायट स्पीकर सर अंडर द कम्युनियन ऑफ लॉ शी स्टील हॅज अ रायट ऑन द हजबंड प्रॉपर्टी. तो कितें सांगतालो स्पीकर सर.
आनी कोण आसा
स्पीकर सर म्हाका दिसता हे बिल क्लियर आसा.
पण कित्याक काडटा जस्ट टेल अस द रिजन. खंयचो ब्रदर इन लॉ आनी कोण सिस्टर इन लॉ ही तुमकां मेळ्ळा.
तुजो ब्रदर इन लॉ तुजो सिस्टर इन लॉ मेळ्ळो.
सांग मरे. गिव दिस नेम. गिव से दॅट म्हजो ब्रदर इन लॉ.
बिल खंयचे स्पेसिफीक कोणा खातीर हाडिना. ओके स्पेसिफीक कोणाच खातीर हाडिना
कितें इतले बिलां हाडपा लागले तुमी
स्पीकर सर आमी पळयता की गोंयच्या कायद्या प्रमाणे प्रॉपर्टी जी आसा पळय न्ही लग्न जाल्या उपरांत म्हणजे मिसेसीक हाफ प्रॉपर्टी ऑटोमॅटिकली वता ओके आनी तिका रायट आसा ओके त्या खातीर म्हणजे ब्रदर इन लॉ
स्पीकर सर एकूच सांगता बेनामी ट्रान्झॅक्शन म्हणून आसता पळय
ऐकून घ्या
कशी जाता अशी कशी जाता ती सांगता तुका
बसून
ना स्पीकर सर हाजेर मातसो मुख्यमंत्र्यान विचार करचो कोण कोणाच्या नांवार घेता कशें ट्रान्सफर जाता आनी ताका गिफ्ट म्हणून दिता आनी ते सगळें लिगल जाता स्पीकर सर हाजेर तुमी विचार करा तुमकां फाल्यां ओगीच कोण कितें कितें बरयतलो आनी तुमची फकाणां करतलो काबरालान जर कोणा तरी हाडला काबरालाक कोण मेळ्ळा जाल्यार डिफरंट हांव म्हणून विचारता कोण तुमकां मेळ्ळा तो सांगचो
स्पीकर सर कोण कोणाकूच मेळूंक ना ओके गोंयच्या कायद्यानुसार परत ना जाल्यार कितें जालां आमी म्हणटा त्या अनुसार ना जाल्यार परत हे जे हर्डल्स क्रिएट जाता पळय न्हू हेका लागूनच म्हणजे ब्रदर इन लॉ आनी सिस्टर इन लॉ ह्या खातीर एटीन ब्लड रिलेशन जरी नासले आसत जाल्यार ताजो रायट्स शेअर्स जो दिवपा खातीर ताका रायट आसा दिवपा खातीर सो दॅट हे त्या खातीर बिल हाडटा
Yes, Minister.
Speaker, sir, I request to move that Bill number 10, 2023, the Union Stamp Goan Amendment Bill 2023 be passed.
Just consideration नका हय मंडळाचे म्हणणे मान झाले हय मंडळाचे म्हणणे झाले विधेयक विचार
डिव्हिजन मागला मरे
विजय मागला
डिव्हिजन मागला
डिव्हिजन मागले त्याने
विजय मागला
आम्ही उभं राहू सर इन फेवर स्टँड अप एल्मर
बावजी पार्टी बावजी काय राव,
27.
बावजी काबराल काबराल बावजी
भाऊजी तुझी काय फाल्या दितात तुझी डिव्हिजन माग आता उभे राहा अगेन्स्ट कोणा ते सांगता
हय मंडळाचे 27
भाऊजी
Against.
मीना असा
7 against 7 येस
एकटो ना जालो पळय
हांव आतां हें विधेयक कलमवार सभागृहांत सादर करता विधेयकाक दुरुस्त्यो नात प्रस्न असो आसा कलम 2 कलम 1 अधिनियमन सूत्र आनी प्रतिमथ्याचो विधेयकाचो भाग जावचो काय कितें जांकां मान्य आसा ताणें हय म्हणचें जांकां मान्य ना ताणें ना म्हणचें हय मंडळाचें म्हणणें मान्य जालां हय मंडळाचें म्हणणें मान्य जालां कलम 2 कलम 1 अधिनियमन सूत्र आनी प्रतिमथ्याचो विधेयकाचे भाग जाल्यात मनसूर मंत्र्यांनी आता विधेयक मानून घेवपाचो प्रस्ताव मांडचो मिनिस्टर
Speaker, sir, I request to move that Bill number 10, 2023, the Indian Stamp Goan Amendment Bill 2023 be passed.
प्रश्न असो आसा विधेयक मानून घेवचें जेका तें मान्य आसा ताणें हय म्हणचें जेका मान्य ना ताणें ना म्हणचें हय मंडळाचें म्हणणें मान्य जालां हय मंडळाचें म्हणणें मान्य जालां भारतीय स्टॅम्प गोंय दुरुस्ती विधेयक 2023 मान्य जालां गोंय अनधिकृत बांदकामाचो अधिनियमनकरण दुरुस्ती विधेयक 2023 रेव्हेन्यू मिनिस्टर
Speaker, sir, I request to move that Bill number 11 of 2023, the Goa Regularization of Unauthorized Construction Amendment Bill 2023, be taken into consideration.
येस प्रश्न असो आसा विधेयक विचारान घेवचें जाका मान्य आसा ताणें हय म्हणचें जाका मान्य ना ताणें ना म्हणचें
स्पीकर सर
Speaker, sir, Rahul Tamre.
सांग बाबूश सांग
Speaker, sir, Speaker, sir, reason for extension of time limit for 90 days of Goa Regulation of Unauthorized Construction Act 2016, Goa Act 20 of 2016. Many persons who have carried out constructions which are coming under the purview of term unauthorized construction, as defined in Section 2H of the Goa Regulation of Unauthorized Construction Act 2016, Goa Act 20 of 2016, have approached the government with a request to extend the time limit for filing of applications for regularization of their unauthorized construction, as they could not file the application within the time limit as specified in the said Act, on account of being unaware of the provisions of regularization of such unauthorized construction contained in the said Act, or due to several other unavoidable circumstances. Many of them have filed application away expiry of such time limit. some of which are pending for final disposal in an inquiry under subsection 3 of section 3 before the authorized officer, while some are pending for final disposal in an appeal under section 7 against rejection of application being made beyond time limit before the government now. Therefore, it is seen that the purpose of the said act stands defeated. It is the above cases, if the above cases are not given opportunity. However, as on date, total 2,445 applications has been rejected out of 8,320 applications for various reasons by the deputy collectors of the concerned talukas.
Yes.
Speaker, sir, the title itself of this bill makes it clear that unauthorized must be made legal and authorized. I would only ask the Honourable Minister, a very specific thing to do is you need to add the incorporated domicile clause so that, Speaker, sir, you protect Goans and there is no misuse of this act.
वो आमी एक्ट हाडिल्लो गेले खेपे जेन्ना LAQ आमी घालो तातूंत आन्सर मेळ्ळें की 5,291 एप्लिकेशन्स रिसीव जाली हय आनीक 1,000 रुपया तुवें घेतले पर एप्लिकेशन 10,000 सॉरी आनी आतां तुवें सांगलां की 2,445 तुवें भायर उडयली आउट ऑफ सम 8,300 स्पीकर सर म्हजो पॉयंटेड क्वेश्चन आहा how many of these applications are pending, accepted and rejected? Sarke exact. Kidak your LAQ gives a different answer. 1 minute. Of this, how many are in one's own land? How many are in Comunidad land? Will houses where temporary house number is given under recent Panchayat Raj Act be eligible for regularization? How will government guarantee that private property is not encroached and claimed under regularization in the future?
Because,
just give me answers to these questions.
This has got nothing to do as far as Comunidad land is concerned. This is only on private lands.
But
yeah.
you will, now, for example, you will encroach on my land.
Yeah.
And illegal construction, and you will give a number and regularize that.
No. Speaker sir, हितूर clear असा own land. पयली act जो आहा पळय न्ही 2014 पयली ज्याच्या स्वताच्या जाग्यान बांधलेले घर
स्वताची जागो म्हणल्यार कितें
ओनरशिप विकत घेतलेलो
ओनरशिप तुजे ओनरशिप बरें आनी हे आतां 2016 चो एक्ट कितें जालो 2016 च्या एक्टान 5,291 एप्लिकेशन घेतली
ते विचार
विचारले
बरोबर आसा 2016 पर्यंत एप्लिकेशन तुम्ही घेतलेली तांचे कितें जालें
5,000 अरे राव रे भाऊजी मातसो बस हो तुझे भाऊजी वतलो घरा गेले की कोळशा कसो करतालो भाऊजीन हाडला आसतले कोण भूमिपुत्र भरपाक हातूंत हे भूमिपुत्र न्ही मरे हे भाऊजीन हाडिल्ले ते भूमिपुत्र लास्ट टाइम
See, as far as the applications are concerned, total application received was 8,320. Disposed applications are 1,046. Rejected are 2,445. Now, some of these applications are rejected because of this delay. And pending application are 4,829.
Yes.
Only one this thing. The Honourable Minister may only clarify that those except which are rejected because they were not filed within time, what guarantee is that they will not apply under this and now get reapply and then be considered again?
No, that's the reason we have given them a chance for another 90 days time. All those applications will be taken into consideration now. Even a new application also will be taken.
Speaker sir, I stand to oppose...
A new application, that's the reason we said whoever missed out the date.
Speaker sir, I stand to oppose this amendment. तुम्ही पळयता आसतले लास्ट टायमूय तांकां एक्सटेंशन दिलें आनी 180 दीस दिले जे अनऑथोरायज इटसेल्फ सांगता की अनऑथोरायज म्हटल्यार इनलिगल स्ट्रक्चर्स जे आसा तांकां लिगल करपाक सोदता आतां मिनिस्टर म्हणटालो की आमी जे गोंयकारांचेच आसा ते करूं सोदता हांव म्हणटा की इनलिगलिटी सगळ्यांनी केल्या कोणानूय करूं त्यो आयज खंय ना खंय ते लिगल करपाक सोदता आयज तुम्ही पळयता आसतले हांगा मेन्शन केला Speaker sir, Muddam 3 of C. Any unauthorized construction by application in undivided property jointly held by a unit of family or family, त्यांका ते legal करू शकता. म्हणजे any. आता तितून तो खंयचोय आसूं आतां ऑर्चर्ड लँडार समज घालता आनी तितून डिविजन करूं ना तेवूय मेन्शन केला. समज खंयचोय इनलिगल स्ट्रक्चर लिगलायज करपाक सोदता आतां एक्सटेन्शन परत वाडयता. आतां हितून प्रमोशन झोपडपट्ट्यांक दिता. सद्याक तुम्ही पळयता आसतले आख्खे गोंयभरान झोपडपट्टे चालूच आसा आनी हेजेर खंयच मेन्शन केल्लें ना की पर्सन ऑफ गोवन ओरिजिन नाव नेटिव्ह गोवन जे नोटरायज एक्टा प्रमाणे पासून आसा नेटिव्ह गोवनाक दिवचो हेंय तेजेर मेन्शन केल्लें ना. म्हटल्यार कोणूय येतले आनी खंयूय बांदतले स्ट्रक्चर.
स्पीकर सर, तो जे आत्तां एप्रेन्शन जे आसा पळय न्ही तेजे कोण आतां बांदपा खातीर न्हय, परत एकदां हांव क्लियर करता. 2014 पयलींचें जेचें स्वताचें घर आसा, स्वताच्या जागेन 114 ताज्या नांवार आसा. ओके, तेणी पार्टिशन केला, म्युटेशन केला, एक क्लियर आहा पयलींचें.
आणि जॉईंट आसा जर जॉईंट आसा जॉईंट प्रॉपर्टी आसा
जॉईंट प्रॉपर्टी आसतली तेजे कडेन, बट तेणी पार्टिशन करून आपली क्लियर केल्ली आसा. ओके, तितून तेणी घर बांदलां. फक्त ते वयल्यान म्हणजे सरकाराक कसलोच रेव्हेन्यू दिनासतना बांदलेलें. ओके, तेद्या वेळार तो आतां सरकार ताका ऑथरायज करता, ताच्या कडल्यान फीज घेता. ओके, आनी भितर वयल्यान थोडेशे एकूच म्हणजे ताका रोड क्लियरन्स सेटबॅक हे ते सगळें वचून इन्स्पेक्शन करता, सगळें करता. आतां कोणाक करपा खातीर न्ही. 2014 तेजी डेडलायन आशिल्ली. 2014 पयलींची ती थोडी एप्लिकेशन्स अजून थोडी कोणी करपाची उरलेली तांकां परत एकदां सरकार ऑपॉर्च्युनिटी दिता. 2014 आनी दुसरी गजाल आसा जस्ट म्हणजे अपोजिशन लिडरान जे उलयले म्हणून त्यांनी रेजिडेन्शियल क्लॉज जर कोणी येवन स्वताच्या जागो कोणा कडल्यान विकत घेतला आनी घर हांगा जर बांदलां जाल्यार तेचें घर रेग्युलरायज जातलेंच. जाल्यार तेणी विकत घेवन बांदलेलें आसा. पार्टिशन म्युटेशन सगळे प्रोसेस कंप्लीट केल्या. आमी ताका आडूंक शकना. स्पीकर सर,
म्हाका सरकाराक एक विचारपाक दिसता. 2016 हाडलें आनी 2023 आतां आमगेले हॉनरेबल मिनिस्टरान मोविन गुदिनान गोवा पंचायत राज एक्टाक अमेंडमेंट हाडलें. तेज्या पडले आमगे TCP मिनिस्टर आशिल्ले तेगले आहा. जाल्यार आमी सजमताय जाल्यार लोकां तरी हे तोकल्यान जाल्यार परसेप्शन आसतलें बाबा एवरी 5 months सरकार जे इलिगल आहा ते आनीक 5 वर्सां आनीक बिल हाडलें आनी परतून लिगलायज करतलें जाल्यार म्हाका सरकार लोकांनी आनी ते लिगलिटीन चोवप ना. टावन एंड कंट्री प्लॅनिंग आनी घालप ना, पंचायती घालप ना. म्हणटकीर सरकार ना. स्पीकर सर, हांव कितें म्हणटा हेच कोण सी वी आर गिविंग अ चान्स टू द पीपल हू वॉन्ट टू डू इलिगॅलिटी. आनी 5 वर्सां आनी एक बिल हाडपाचें आनी मागीर 5 वर्सां गेलें तेंगे परतून मागीर लिगल कराय. हें करीत रावपाचें. मागीर लिगल डिपार्टमेंट कितें आहा, पंचायत कितें आहा. 5 वर्सां सरकार म्हणटलो आनी कोण सरकार येतलो आनी एक बिल घालतलो आनी रेग्युलायज करतलो. सो दीस वील कंटिन्यू. सो देर इज नो वी शुडंट हॅव एनी डिपार्टमेंट, वी शुडंट हॅव द पंचायत. Let after 5 years, let them put an application and again regularize this construction. Why we have to do that?
स्पीकर सर, आमचे इंटेन्शन क्लियर आहा. आतां कोणाकूच इलिगल घर बांदपा खातीर कोणूच परमीट करिना. ओके, तेजेर डेमोलिशन म्हणजे डायरेक्टर ऑफ पंचायत, म्युनिसिपालिटीज, डेप्युटी कलेक्टर्स हे सगळे कोणी जर कंप्लेन दिली आसत जाल्यार तेजेर एक्टूय जाता. ही घरां जी सगळी आसा पळय न्हू ही 28/12/2014 हाज्या पयलीं म्हणजे जी घरां ते बी कशा पार्टिशन म्युटेशन हे सगळे कंप्लीट करून म्हणून सांगतात. दुसऱ्याच्या जागेन गव्हर्मेंटाच्या जागेन बांदलेली हे क्लियर करता परत. ओके, कोमुदातीच्या जागेंतलेंय न्हू. ओके, जी ओन स्वताच्या जागेत बांदलेली घरां त्या खातीर तेजे जे एप्रेन्शन आसा परत म्हणजे कोणूय येतलो खंयसरूय बांदतलो, कोण कोणाक बांदूंक दिना आनी कोण कोणाची अशी घरां सर म्हणजे कोमुदातीच्या हितूर स्पीकर सर परत गव्हर्मेंटाच्या जागेत बांदलेली आहा ती डेमोलिश जातली. परत सांगता म्हणजे तशें जर आसत म्हणजे गव्हर्मेंटाच्या जागेत बांदलेली आसत आनी इलिगली आसत आनी हेज्या फुडें कोण बांदता आसत जाल्यार डेमोलिश जातली.
स्पीकर सर, वॉट आय जस्ट वॉन्ट टू मेक अ पॉयंट इज दॅट लोक कितें जाता हे तोकल्यान दोन
आतां तेज्या मतदारसंघात जर गव्हर्मेंट प्रॉपर्टीन बीन कोणी बांदला जाल्यार दिवनी.
आमगे केप्यां लास्ट 20 वर्सां कितलीं इलिगल आहाय. केप्यां मोलो आहाय. आय कॅन शो यू द सर्वे नंबर्स. आय हॅव डिटेल विथ मी. नाव आय गेलो. आय जस्ट वॉन्ट टू आस्क द हॉनरेबल टाउन एंड कंट्री प्लॅनिंग लास्ट असेंब्ली घायला आज पासून तेजे कांय जालें ना. I have दिता हांव सर्वे नंबर. स्पीकर सर, what I am saying is that हे तुमी इन्फ्लुएन्स कोताय for the people to do illegality because they know after 5 years they will again to do, you all will legalize it.
2014 पयलींची त्यांच्या ओन प्रॉपर्टीन घरां आसत जाल्यार ती डायरेक्टली रेग्युलरायज करपाक घालपाक लाय आनी जर नासत गव्हर्नमेंट प्रॉपर्टीन बी आसत जाल्यार नांवां दी.
सर स्पीकर सर वॉट आय एम सेइंग इतले ते लोकांनी लिगल केले ती बिस्ती घालपाची तें करपाक नाकाल्लें वाय दे टू रन फ्रॉम पिलर टू पोस्ट टू डू ऑल दिस.
परत एकदा सांगता ही बेस्टी करिना हेंची फायन घेतली वता. इट इज पयलीं त्यांची सर्वे करपाक समथींग 10,000 रुपीज घेता आनी मागीर अकॉर्डिंग टू दॅट त्यांची फायन एक 50 to 1 lakh रुपीज पर्यंत कितें तरी तांकां फायनूय पडटा आनी रेव्हेन्यू कलेक्ट एज पर द एरिया एज पर एरिया वी आर चार्जिंग देम. कोण बेस्टी डायरेक्ट ऑथरायज करिना.
In fact, this has to change.
Discussion, Cruz Silva.
And not more than 250 be including
Speaker, sir.
एक मिनिट Cruz Silva.
स्पीकर साहेब
या बसून घे.
म्हाका मातशें जाण जावपाक जाय आसलें हांगा रेग्युलरायज केला ती फाटली जे रोड वायडनींग एरिया कोण एप्लिकेशन कितले रेग्युलरायज जाले रोड वायडनींग एरियांक.
Road widening areas is not been considered.
Secondly, orchard property.
Orchard property also is not considered.
So as per my information, Mapsa, Bardesang, Orchard and Dilla, Salsed and Marmagua Dilla.
They have got to
Because sir, I would like to tell you,
Speaker, sir,
that properties in Orchard
Bardesang Dilla, Orchard and Dilla.
sorry, orchard is considered, but they'll have to pay a fine after that.
Yes.
घरां जी आसा जेन्ना कायदो काडलेलो 2014 एका 250 स्क्वेअर मिटर तितली 200 स्क्वेअर मिटर घर आणि 50 स्क्वेअर मिटर कमर्शियल यूज तेज्या वयर घराची रेग्युलर जायना आतांय जायना सर स्पीकर सर. आणि हितू भितर नो डेव्हलपमेंट झोन CRZ एरिया बाकीचे एरिया ना इंटू जे TCPच्या एक्टा अंडर क्लास 2 म्हणजे तितू भितर सेकंड हितू ती सगळी रेग्युलर जाता स्पीकर सर.
स्पीकर सर आत्ता मंत्र्यान म्हणला आणि मुख्यमंत्र्यान आमकां सांगला की अंडर दीस 2016 रेग्युलरायझेशन गोवा रेग्युलरायझेशन ऑफ अनऑथरायज्ड कन्स्ट्रक्शन एक्ट 2016 हातून कुमुंदाद लँडीचेर आमी करूंक ना म्हणून. बट एक क्वेश्चन आशिल्लो बाब दिगंबर कामतीचो 15/7/2022 म्हळ्यार गेल्या सेशनान LAQ number 8A दिगंबर कामत टू बी आन्सर्ड ऑन 15/7/2022 हाजेर तुवें उत्तर दिलां रेव्हेन्यू मिनिस्टरान. नांव वाचून दाखयता तुका हांव. एक मिनिट हां. दिलीप रंगा जाधव रेजिडेंट ऑफ तेलियावाडो कोळवाळे 161 सेल डीड केला कुमुंदाद लँड आनी रेग्युलरायज केला. मागीर पळय आयक यलप्पा नगप्पा बुडगोली कोळवाळे 110/1 सर्वे नंबर 85 स्क्वेअर मिटर सेल डीड. आता कुमुंदादीन सेल डीड केली कशी आणि तुम्ही रेग्युलरायज केले कशें. स्पीकर सर हे आन्सर गिवन इन दीस हाऊस बाय द गॉड टू द गॉड मॅन दिला. आणि हे कोळवाळेचे इश्यू हे अशी कितलीच आहा. स्पीकर सर हाजे खातीर जे बाबा एल्टर म्हणते सारखे यू आर गिविंग अ सिग्नल सगळ्यांक की बाबा या बाना आणि खाओ पिओ मजा करो गोवा में चलता है सब.
You just give me.
स्पीकर सर भाऊजीचे मातशे हे करा तुम्ही. हो भाऊजी उलयता म्हणून की बिला पास करू नका.
Sir, let the honorable member give me the details. I will inquire into the matter.
हांवूय लिस्ट दिता. लास्ट टायम आमी दिल्ली आसा सीएमान म्हटला की लिस्ट दिया म्हणून. लास्ट टायम हांवें प्रोवायड केल्या मिनिस्टराक पावल्या आसतले काय खबर ना. नॉर्थ गोवा कलेक्टराक पावल्या. गव्हर्नमेंट प्रॉपर्टीन स्ट्रक्चर बांदल्या जशें कोमुलदाद प्रॉपर्टीनी स्ट्रक्चर बांदल्या इनलिगली जावं तांकां रेग्युलायज करपाचो आमी लिस्ट दिता. एक्शन घेयत ना. एवरी टायम ते फुडें व्हरता. हांव सीएमाक लिस्ट दिता हे फावट काडून. सीएमान आतां मेन्शन केला तूं लिस्ट काडून दिता.
Speaker sir,
तुझ्या पयलीं दी
खुबश्यो इनलिगलिटी आसा तेजेर लिस्ट आमी दिता. सीएमान एक्शन घेवची.
Speaker sir, as far as the Komunidad land is concerned, is the managing committee of the Komunidad. Basically, they must initiate the action against them.
Government property.
No, government
already दिल्ली आसा. हांव सीएमाक दिता.
कन्सिडरेशन घालपाचें.
I put it already for this thing.
5 मिनटांचे म्हणणे मान्य जालें. 5 मिनटांचे म्हणणे मान्य जालें. विधेयक विचारांत घेवपाचो प्रस्ताव मान्य जाला. हांव आतां विधेयक कलमवार सभागृहांत सादर करता. विधेयकाचे दुरुस्ती नात. प्रश्न असो आसा कलम 2 कलम 1 अधिनियमन सूत्र आणि प्रदीर्घ पथ्याचो विधेयकाचो भाग जावचो काय कितें. जाका मान्य आसा ताणें म्हणचें.
हय
जाका मान्य ना ताणें ना म्हणचें. हय मंडळाचें म्हणणें मान्य जालें. हय मंडळाचें म्हणणें मान्य जालें. कलम 2, कलम 1 अधिनियमन सूत्र आनी प्रदीर्घ मथळ्याचो विधेयकाचे भाग जाल्यात. महसूल म्हणजे आतां विधेयक मानून घेवपाचो प्रस्ताव मांडचो.
Speaker, sir, I request to move that Bill number 11, 2023, the Goa Regulation of Unauthorized Construction, Amendment Bill 2023 be passed.
येस. प्रश्न असो आसा विधेयक मानून घेवचें जेका तें मान्य आसा तेणें हय म्हणचें.
डिव्हिजन 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 म्हाका
डिव्हिजन
डिव्हिजन
येस.
कोणा डिव्हिजन सांग उबें करपाक चल.
डिव्हिजन चल. येस.
तो गेलो भायर, तो ना तुज्या वांगडा तो पळय.
हां. येस.
जालें. राव यो बेगीन राव.
20.
येस.
27. येस.
डिव्हिजन एक शब्द येयलो तो डिव्हिजन. चल.
चल.
कोवपाक जाय पास केलो.
1, 2, 3, 4, 5, 6.
तो ना आता तुमच्या वांगडा.
6.
आता रे उलोवपाचें ना एल्टन.
6. 27. येस. प्रश्न असो आसा विधेयक मानून घेवचें जेका तें मान्य आसा ताणें हय म्हणचें.
8 जाण मेले.
जेका मान्य ना ताणें ना म्हणचें. हय म्हणटल्याचें म्हणणें मान्य जालें. हय म्हणटल्याचें म्हणणें मान्य जालें. गोंय अनधिकृत बांदकामाचे अनियमितीकरण दुरुस्ती विधेयक 2023 मान्य जाला. गोंय शार आनी नगर नियोजन दुरुस्ती विधेयक 2023.
Sir, I request to move the bill number 3 of the 2023 Goa Town and Country Planning Amendment Bill to be taken into consideration.
प्रश्न असो आसा विधेयक विचारान घेवचें जेका तें मान्य आसा ताणें हय म्हणचें. जेका मान्य आसा ताणें हय म्हणचें. जेका मान्य ना ताणें ना म्हणचें. हय मंडळाचें म्हणणें मान्य जालें. हय मंडळाचें म्हणणें मान्य जालें. विधेयक विचारान घेवपाचो प्रस्ताव मान्य जाला. आतां विधेयक कलमवार सभाघरांत सादर करता. विधेयकाच्यो दुरुस्त्यो नात. प्रश्न असो आसा कलम 2, कलम 1 अधिनियमन सूत्र आनी प्रदीर्घ मथळ्याचो विधेयकाचो भाग जावचो काय कितें. जेका मान्य आसा ताणें हय म्हणचें. जेका मान्य ना ताणें ना म्हणचें. हय मंडळाचें म्हणणें मान्य जालें. हय मंडळाचें म्हणणें मान्य जालें. कलम 2, कलम 1 अधिनियम सूत्र आनी प्रदीर्घ मथळ्याचो विधेयकाचो भाग जाल्यात. शार आनी नगर नियोजन मंत्र्यांनी आतां विधेयक मानून घेवपाचो प्रस्ताव मांडचो. मंत्री.
Sir, I request to move the bill number 3 of 2023, the Goa Town and Country Planning Amendment Bill to be taken into consideration.
येस. प्रश्न असो आसा विधेयक मानून घेवचें जेका मान्य आसा ताणें हय म्हणचें. हां. येस.
Consideration.
जालें.
Statement, Speaker, sir.
Okay. Yes.
The bill seeks to amend Section 17 of the Goa Town and Country Planning Act 1974, Act 21 of 1975, so as to provide for rectification of errors in the regional plan, correction and consistent, coherent zoning proposals in the regional plan in accordance with the rules that may be made in this behalf.
Speaker, sir, the Honorable Minister has moved this amendment. It is proposed to Section 17. I would like to ask the Honorable Minister, Speaker, sir, when you have brought this amendment, in 16B चेर जायत चर्चा जाली. What is the status? तें आहा, stopped, kept in abeyance, मुखार under study, कितें आहा, open आहा, close आहा, तेजेरूय माननीय मंत्रीन मातशें हावजा सांगचें.
हॅलो स्पीकर सर. जेन्ना माननीय मंत्रीन हे न्यू अमेंडमेंट हाडा लास्ट टायम हांवें सांगिल्लें आनी इनफॅक्ट आय फॉलोड अप फॉर द लास्ट 4 months. जेन्ना आतां ऑनरेबल चीफ मिनिस्टर सांगता म्हाका थोडे नंबर दे म्हणून. हांवें सर्वे नंबर एक्चुअली म्हगे क्वेश्चन आहा ते सर्वे नंबर 23/1, 23/39, 29/1, 29/58, 30/1, 30/88, 31/1, 31/118, 32/1, 32/127. There are list of this survey numbers and major survey number 130/, just show you, 130/7 village Shirvoi Kepe, village Odne, village Amona. You soglo itle. I was asking the Honorable Minister 16B aha na ani open or closed ne. So last time झाले. आता तू म्हाका 4 म्हयने झाले. I am following up with the department also. There is there is no absolutely no clarity. कांयच ना. आता ते पळय 16 आहा or ना ते सांग मागीर bill pass करूया. पयलीं हें कितें So in that there is something else or what it is. You just clarify this. Now file ती suitcase open or close. I म्हणलां ते.
Speaker sir, हे जे bill section 17 amend करपाक हाडलां, हे shortcut which was tried through earlier 16B, हे न्ही म्हणून कित्या वयल्यान हे मंत्र्यान सांगचें पडटलें. हे नंबर 1. आयक 16B चे परते हांव सांगता. 16B हाडपी हांव. आयक रे, कंप्लीट कर न्ही मरे. 16B हाडलें आनी 16B मागीर ओपन, आनी तुमी अशें ओपन केलें की ते क्लोज वचून जायना, ओपनूच आहा. तो सांगता तें
सारकें
ओपनाचेर तुमी चलयला येदो व्हडलो गल्लो. हांवें केल्ले 32 केसी, तुमी केल्ल्यो 6700 केसी, आनी हांवें 32 केसींनी जर गल्लो केल्लो जाल्यार आज मेरेन हांव भितर आसपाचो. तुमी म्हाका सोडपाचें न्ही. स्पीकर सर, आतां हें नवें दुकान, नवो गाडो हो ताजेर कसो न्ही हो मंत्र्यान सांगचो पडटलो. एक. दुसरें म्हणल्यार section 17 कितें म्हणटा, if the government at any time after a regional plan has been published in official gazette is of the opinion that a revision of such a regional plan is necessary, it may direct the chief town planner to undertake the revision. आता हे undertake revision करपा खातीर आता आमचो horizon period regional planaचो सोंपला. सो नवो regional plan कित्याक जायना? ऑलरेडी गव्हर्मेंटा कडेन प्रोविजन आहा zoning plans करपाचे. केरला अशी स्टेट आसा जी स्टेट बरोबर एक धपक्याक रिजनल प्लॅन करपाक घेना. ते डिस्ट्रिक्ट वायज प्लॅनिंग करतात. हो डिस्ट्रिक्ट जालो, तो डिस्ट्रिक्ट जालो. हांगा मंत्र्यान हे तालुका वायज कित्याक करना? बट वाय डू अशें दर्या भंय दिसता की सगळो रिजनल प्लॅन केलो जाल्यार तो जावचोच ना. बरें आहा, तूं तालुका वायज कर. पूण पॉयंट असो आहा स्पीकर सर, इट शूड नॉट बी अ शॉर्टकट टू चेंजिंग झोन्स विच आर इको सेन्सिटीव. डिस्ट्रक्शन ऑफ इको सेन्सिटीव एरियाज म्हणटा ताजेर सारको दोळो आसूंक जाय, गॅरंटी आसपाक जाय. एक हातून इनएडवर्ट एरर्स म्हणटा पळय, रेक्टिफिकेशन, हाका एक केस आसा. कित्याक 4 crore square meters of land which was in the settlement zone in the regional plan of 2001 was made into orchard in 2021, and 8 crore square meters of land which was in orchard zone was converted into settlement. हो अन्याय त्या लोकांचेर जाला. तो अन्याय तो तांकां जर न्याय दिवपा खातीर हें सेक्शन हाडटा. इट कॅनॉट बी रॉंग, बट एट द सेम टायम इट शूड नॉट बी अ लायसन्स. इट शूड नॉट बी अ लायसन्स, स्पीकर सर, to bring the same thing what was initially planned under 16B, and how the minister will convince the house. That is the issue. ना जाल्यार कितें जातलें की आमी हाडिल्लें आतां हे पळय उबे रावले आनी सपोर्ट करतात म्हणून. आमी तशें सपोर्ट करपाक हांगा येवंक ना. We have come to find out your true intentions.
Speaker sir, I want to place on the table of the house the report from the department, town planning department, and जे आमगेले केप्यां आमोण्या आमगे श्री चंद्रेश्वर भूतनाथ हेंगेले लोक ते देवासाक मानता आनी भितात तेंगेले जमीन हिल कटिंग केलोले मुको रिपोर्ट आहा फ्रॉम द डिपार्टमेंट. ऑनरेबल मिनिस्टराकूय सांगूं सोदता, I have a report from your department where that hill cutting has been done and they have admitted it is of Sri Chandreswar Bhutnath amgele kepya te devalache property. There is a issue report. I want to place it on the table.
Because sir, I would like to oppose the bill number 3 of 2023 amendment to TCP Act. The bill proposes to amend the TCP Act to enable the government to instruct the CTP to amend RP for rectifying inadvertent errors and correction inconsistent to incoherent zoning policies. The bill is unlawful because it is a shortcut for illegal changing zones of lands, as was earlier tried through 16B, which has been widely opposed as it allows corrupt changes in zones to help profit-seeking speculators.
Under Rule 16, the rule of procedure and conduct of business, I move a motion to extend the duration of the sitting of the House by 2 hours. Mike.
The motion is that the duration of the sitting of the House extended by 2 hours. Those who favor ayes. Aye. Those who favor no. Ayes have it. Ayes have it. The duration of the sitting of the House extended by 2 hours.
Okay, this amendment is contrary to Section 11 of TCP Act itself, which requires prior social, physical and economic studies before changing zones. It grants unfettered powers to change zones without any proper studies, thus allowing corruption and nepotism. Number 4, guidelines for change in zones under this provision must be included in the Act itself to prevent any corruption and destruction of eco-sensitive areas. As an example, the following guidelines could be given to prevent abuse of this provision. Changes from ecological sensitive zones to settlement, industrial, institutional zones are permitted only for existing legal structures and land uses, not for any further changes for construction. And the last point, changes from settlement, industrial, institutional zones to appropriate ecological sensitive zones must be carried out where settlement zones are wrongly shown in sloping lands, NDZs of CRZ, tenanted agricultural lands, common lands, water bodies and their buffer zones, forests including open forests as per Supreme Court orders, plateaus, irrigation command areas and other prime agricultural lands, wetlands and low-lying areas. Speaker sir, I would like to present it and put it in the House.
Yes. Minister. शहर आणि नियोजन मंत्र्यांनी आता विधेयक मानून घेवपाचो प्रस्ताव मांडचो.
स्पीकर सर, आमचे थोडे क्वेश्चन जे आहा ते ताणे क्लॅरिफाय करचे न्ही.
स्पीकर सर, जे आम्ही रिव्हिजन हाडलेले आसा, जे अमेंडमेंट हाडलेले आसा ह्या टाउन प्लॅनिंग एक्टान and section 17, I just want to make it very clear to Honorable Member Shri Vijay Sardesai, this is totally different from 16B. This is totally different, and mainly what has happened, as you are aware, you just mentioned about the figures in the regional plan that was prepared, and in a lot of irregularities that happened in 2000, after 2001 was already finalized, that a lot of properties, a lot of private properties, roads have been shown wherever they want, and also playgrounds, garbage treatment plants in private property, which needs to be rectified. You cannot wait for a regional plan to come to have it rectified. People have suffered for a long time, and these irregularities and these incoherent things that have been done need to be rectified. So in brief, I just want to make a mention that the amendments that we have proposed to the Town and Country Planning Act are primarily aimed at giving powers to the government to modify, revise the regional plan, to rectify errors which have crept into the plan, to correct the zoning proposals which are inconsistent or lack any kind of rationale which was there in the 2021 plan. Considering the pace of development of the state, these powers are very important, because state is not impeded or slackened because of the long time gap in finalization of 2 regional plans, which is actually the fact. For example, there are large projects that are coming up like MOPA and other things. Honorable Chief Minister has also mentioned, and also whatever needs to be done around in terms of creating a right type of ecosystem. One cannot wait for the next regional plan in the event there are any modification required, which fall within the purview of the proposed amendment. This power will also ensure that nobody suffers prejudice on account of inadvertent errors and zoning proposals. Power is not in any manner unfettered. Just like my friend Mr. Venzi mentioned, it is a regulated power intended to benefit for the state. The said provision is conceptually and fundamentally different from 16B. 16B is a provision which relates to changing of zone on basis of individual application received by the government and operates for different purpose. The proposed amendment is a broader power to the government for correction, rectification and modification of the regional plan based on the prescribed rules. The process of effecting modification revision is fair and transparent. Necessary guidelines will be framed to ensure that ecologically sensitive zones, and especially ecologically sensitive zone 1, are protected and there is no breach of existing environment laws. As also there is a process in place, there is no question of any misuse and abuse of power. This is in a nutshell the whole thing. Rather than me, each one who has raised, as Mr. Elton also Honourable Member talked about 16B. We have already taken a decision on 16B. We have put it, it's already sub judice.
No, what, see, Speaker sir, decision on 16 we heard, but we never heard the execution of that decision.
Because
we heard it in the House,
yeah, we have heard last time also the decision was heard, but nothing has been
16B, आम्ही सगळे केसीस अभेन्सान दवरल्या कारण ते सबज्युडिस आहा. त्याच बरोबर आम्ही ठरयल्लें आसा की ते केसीस जे कितें नॉट फिटिंग इन दोज गायडलायन्स टू बी टेकन ऑफ. And as a
how many of them are related?
So
in board meeting and decision
because
board meeting
case.
How many of these cases are there which don't fit it with your guidelines?
No,
in 16B?
Speaker sir, J 16B J cases, you know that the whole thing started with about 60 cases, which were which according to the petitioner whoever had filed a PIL was not in confirming with the guidelines. So after that, what we decided is when we took a decision in the board is to take away all these cases and relook at it. As a result of which the Chief Town, Mr. James Matthew was appointed as the head of the committee to examine these cases and go through it in detail. But as far as at the moment, we have said it is totally non-operational 16B. As far we have not taken a single case.
How many projects that have been approved under 16B finalized? How many projects have been completed?
Speaker sir, वो आयज आमी अमेंडमेंटाचो विषय आमी मांडटा. तो जो विषय हा तो
Speaker sir, this is rectification of the regional plan.
Speaker sir, तो जो विषय आसा 16B चो जो विषय आसा तो आमी सध्या आमी अभेन्सान दवरल्या आनी मेन म्हणजे कितें आसा बोर्डान बी डिसिजन घेतलें आसा की 16B ची आमी खंयचीच केस घेवची ना कितें घेवन काय अर्थ ना आमी ते केसी ज्युडिशरी कडेन फॉलोअप करीत आहा. पण त्याच बरोबर त्यो केसीस जे तांकां कमिटीक योग्य दिसतले पूण एट द मोमेंट आमी ठरयला की आमी बोर्डान जुने केसीसा कुशीक दवरल्या.
Speaker sir, 1,200 cases sub judice are in abeyance, but 6,000 cases you have the power to scrap it, say that is gone. 1,200 are in abeyance in sub judice. Baki 6,000 आहे तो कितें? That you have the power. That is not sub judice.
Speaker sir, already जे 1,000 and odd cases, 1,000 and odd cases, those are the only cases which the committee is reviewing, which have got their final this thing. But तुझे पहिली
that is what I am trying to say, sir. That 1,200 cases are sub judice, but 6,000 आहे the application. You say that is.
बाकी सगळे board has already scrapped it.
You are saying in kept in abeyance. You are not saying that it is kabar.
Still there are 1,000 and odd cases which.
So that is sub judice, no? So that let it be sub judice. But 6,000 cases.
Your 6,000 and odd cases is as good as they have to reapply.
As good as, but it is not.
Operation. They have been scrapped by the board.
So say that it is been.
Because sir, एकूच आमचे भंय कितें आहा 16B केल्लो अशेंच नोबल इंटेंशन आशिल्लें. एक परिस्थिती हांव 16B मूव करपी मनीस हांगा येवन उबो रावन सांगूंक लागलो 16B स्क्रॅप कर म्हणून. कित्याक म्हणपाक लागलो? कित्याक 16B चो दुरुपयोग जालो, सारको होलसेल दुरुपयोग जालो. आतां आमचो एकूच प्रश्न मंत्र्याक असो आहा, 16B आशिल्ल्यो केसूच 17 येतल्यो. कित्याक एक मिनिट जस्ट आय एम टेलिंग यू, एक मिनिट मंत्री आता आयकुचें. इंटेंशन इज द सेम. इफ injustice has been done to me from 2001 to 2021, I went to 16B. That is scrapped now, or it is sub judice. So what I do? I come under 17. Nothing wrong. Nothing wrong. I am not saying it is wrong, but the point is, ह्यो केसी होलसेल पडत्यो येवन त्योच केसी 17 भितर येवच्यो आमी कित्याक वयल्यान.
स्पीकर सर, होलसेलान कितें जालें म्हाका खबर ना, कित्याक म्हाजे कडेन काय होलसेलान जायना.
ना तुका सांगला ते भशेन आमदारान ओपन जाला क्लोज जावंकूच ना.
करपाक जाय ते आतां पळोवचें पडटलें. आतां होलसेल रिटेल बी आतां ते हाडपाक आतां शब्द वापरल्यार 16B चो विशय जो जालो ते 16B चो जालो आनी ते कोर्टान आहा. ते कांय कोणाक फायदो ना तेजो. ते 16B जे जाले ते सगळे शिरकाला ते कोर्टान आनी कोर्टान आतां काही जजमेंट बी दिवंक ना. ते कांयच तुमी फुडें डिपार्टमेंट फुडें व्हरूंक शकना. तेजेर काही आमी फुडें आमी डिस्कशन बी करून काय अर्थ ना की सबज्युडिस. बेसिकली तुम्ही जे उल्लेख करता की 16B
तू डायरेक्ट कोर्टान सांग मरे की आमी स्क्रॅप केला सगळे केसी भायर म्हणून.
आणि सांगता स्पीकर सर कितें स्पीकर सर ते कंप्लीट करू तो आन्सर करता न्ही स्पीकर सर. जाप करून स्पीकर सर.
स्पीकर सर, बेसिकली वो विषय जो हा आताच उल्लेख 2-3 बिलां जाली जे आमी स्पश्टीकरण मुख्यमंत्रीन बी दिल्ले जाय त्यो गोष्टीचेर. पण कितें आसा की राज्य आमी थारू शकना. आमकां जर फुडें वचून लोकांक न्याय दिवंक जाय आमकां वेगळे तरेन विचार करचो पडटलो. फाल्यां कोणी कायदेशीर सबज्युडीस म्हणून आमी दीस कितले काडटले. लोकांचे जमनीवन जर आमी प्लेग्रावंड दाखयले, लोकांचे जमनीवन आमी जर रस्ते दाखयले, जर आमकां कितें मॉडिफिकेशन करपाक सरकाराकूच पावर ना आनी सरकार तशेंच उरले. आतां आमी जेन्ना चर्चा करतले प्रत्येक गोष्टीक वाट काडपाची गरज आसा. प्रत्येक गोष्टीक संशयचेर पळोवपाक गरज ना. आयज कोणाचे संशय असल्यार तुमकां एज इट इज तुमकां सगळे गोष्टी आतांच विजयान सांगले प्रमाणे RTIच्या माध्यमांतल्यान सगळे गोष्टी गावता. माझ्या डिपार्टमेंटान बी RTIच्या माध्यमांतल्यान तुका जाय तशी तुका म्हायती गावतली. जर तेजो दुरुपयोग जालो, तेजो परिणाम कितें जावपाचें आमकां सगळ्यांक खबर आहा. ते दुरुपयोग जाल्यार परिणाम जातलो, पण दुरुपयोग जावना जाल्यार ते पयलींच आमी ते दुरुपयोग जातलो म्हणून कित्याक म्हणून तेजेर संशय काडपाचो. म्हाका तरी दिसता स्पीकर सर की पयलीं जें कितें घडलें सगळे आमी म्हणटा की एक्सपर्ट्स म्हणून, पण सगळे एक्सपर्ट्स करता ते सारकें नासता. एक्सपर्ट्स केन्ना केन्ना सत्यानाश करून दवरता. हे रिजनल प्लॅन 2021 सगळे म्हणटाले इतलो बरो व्हडलो प्लॅन, ते व्हडलो प्लॅन कितें, ते व्हडलो प्लॅनान व्हडलो स्कीम ऑफ इव्हेंट्स आशिल्लो आनी आमकां तेन्ना कोणाकूच कळोंक ना कितें जालां तें. आनी मेन म्हणजे कितें आसा, मुख्यमंत्री आसा, मुख्यमंत्री कडेन चर्चा आमी केल्या, पूण त्याच बरोबर सामान्य मनशाची एक मनीस स्पीकर सर, हांव तुमकां उदाहरण दिता. सांताक्रूज तो रावता, एक ल्हान फॅमिली, तो आयुश्य काडलें तेणी ते रेक्टिफाय करपाक. ते जे कितें कर्मा केल्ल्यो 2021 तो एक्सपायर जावन गेली, तेजी आतां बायल फॉलोअप करता. सेटलमेंट आशिल्ली 2001 आनी 2021 जालें ते ऑर्चर्ड जालें परत. आनी ह्या तरेच्यो जायत्यो गोश्टी आहा. कित्याक म्हणून न्याय दिवपाचे ना. आयज हावस आहा, प्रत्येकाक दिसता आपल्या मतदारसंघात. आतां एल्टनान प्रश्न विचारलेलो ते आयल्ले, फाल्यां आसता दिसा म्हाका ते केप्याचे कितें डेव्हलपमेंटाचो विशय. जायत्यो गोश्टी आसा जे खंय कोणाचे 2001 जो बेस प्लॅन आशिल्लो, 2021 आमी व्हडले म्हणटाले, व्हडले बरे जाल्ले प्लॅन, एक्सपर्ट्स इतले हाडले, पूण एक्सपर्ट्स हाडले म्हणून सदां योग्य तरेचे आमकां न्याय गावना. म्हणूनच हांव विनंती करता, प्रत्येक मेंबरा कडेन विशय आसता आपल्या मतदारसंघाचो. वेन्झीक पयर हांवें सांगलें, आमी बेश्टे खंय लॉबीन आमी मेळ्ळे. बेनावली आसा, बेनावलीन जर अशें कितें डिस्क्रिपन्सी असल्यार न्याय कोण दितलो मागीर. तुम्ही रावतले 5 वर्सां, रिजनल प्लॅन येतले. आतांच विजयान सांगले प्रमाणे केरला, तेंचे प्रत्येक राज्यान आमी आतां ऑलरेडी मुख्यमंत्रीचे ह्या सरकारान आमी ऑलरेडी झोनींग प्लॅन हाडलेले आसा. आमी जाय तसो आमी विशय फुडें व्हरूंक शकता. मॉडिफिकेशन आनी रिविजन आनी जे कितें रेक्टिफिकेशन जाय ते सामान्य मनशाच्या दृश्टिकोनान, फक्त श्रीमंत लोकांच्या दृश्टिकोनान न्हू, पूण सामान्य लोकांच्या दृश्टिकोनान ते तरी करपाक आमकां सरकारान हे निर्णय घेतलेले आसा. हे म्हाका दिसता आमकां फुडें व्हरूंक जाय स्पीकर.
शार आणि नगराच्या मंत्र्यांनी विधेयक मानून घेवपाचो प्रस्ताव मांडचो.
Sir, I request to move the Bill number 3, 2023 of the Town and Country Planning Amendment Bill 23 to be passed.
प्रश्न असो आसा, विधेयक मानून घेवचें. जेका मान्य आसा ताणें हय म्हणचें, जेका मान्य ना ताणें ना म्हणचें. हय म्हणटाचें म्हणणें मान्य जालें, हय म्हणटाचें म्हणणें मान्य जालें. गोंय शार आनी नगर नियोजन दुरुस्ती विधेयक 2023 मान्य जालां. गोंय जमीन विकास आनी इमारत बांदकाम नियम दुरुस्ती विधेयक 2023 शार आनी
Sir, I request to move the Bill number 4 of the 2023, the Goa Regulation of Land Development and Building Construction Amendment Bill 23 to be taken into consideration.
प्रश्न असो आसा, विधेयक विचारांत घेवचें. जेका मान्य आसा ताणें हय म्हणचें, जेका मान्य ना ताणें ना म्हणचें.
Statement and objection reason. The bill seeks to amend Section 8 of the Goa Regulation and Land Development Building Construction Act 2008, Goa Act 6 of 2008, so as to enable the government to relax any provision of regulation framed under the said act to extend as may be prescribed by rules for the purpose of implementation of the government policies, including land development for inclusive housing and affordable housing.
Yes.
This particular bill, the Goa Regulation of Land Development and Building Construction Amendment Bill 2023. Speaker, sir, this amendment will bypass the Goa Regulation Land Development and Building Construction regularization of 2010 for certain housing projects. Now, Speaker, sir, the Honorable Chief Minister is also here. The Honorable TCP Minister is also here. I would like to ask the Honorable Minister, Jay Magadista, I had raised this issue last time with a housing project. I think Sankar Pamonkar was also there on record that time, but he had raised it. with regards to एक मुखेलमंत्री तुवें हेजें आयकचें मातशें with regards to this housing project coming up in कांकणामोडी तूं पावल थिंगा आतां तूं ते येता जायतपुसा येता आमगे कॉन्स्टिट्युएन्सी येता रायटां दिसती पडटा there is a major destruction and this destruction speaker sir म्हाका दिसता I was given a assurance in this house that it would not go through. आज त्यो file municipality येलो है and there seems to be an housing project. Dongor disti pata. This is an aquifer. Such type of things speaker sir needs to stop. I request the Honorable Minister to first answer to this and the Honorable Chief Minister. Tu think yaita tu choila right? Kangnamodi, Panjorkoni, right aha de. तो एक एक्विफायर आहे थिंगा आमगे आज आहा थिंगा ते जाग्या वयलो तुमी संकल्पान थंय गेले त्या पुसा म्हाका सपोर्ट केल्लो पूण हांव मागोता हें जें डिस्ट्रक्शन थिंगा जावपा आहा हें बंद जावपा जाय सो डिस्ट्रक्शन
स्पीकर सर आतां ऑपोजिशन लिडरान सांगलें एक केस मिस्टर विश्वजीत राणे यू आर मूविंग अ बिल ही इज गिवन अ केस टू यू. Does this fall in the category of inclusive housing? I don't know what is this inclusive housing. तुझ्या आता definition, objection तुवें घाला inclusive housing and affordable housing. Affordable I understood. What he is saying, how is it not falling in inclusive housing? What is this inclusive?
He has not said that whether it falls in inclusive.
I am asking you. I don't know the definition of inclusive housing.
He has not asked whether.
No, he is giving you an example.
He has raised apprehensions of that project. He has brought it to my knowledge also. I am examining it. I have called for the file today itself.
No. What is your definition of inclusive housing?
Definition of inclusive housing, which I have been, which we generally. What is happening is that initially, in any, which we have to still prescribe the rules and figure it out we have figured it out what we want to do. Earlier it used to be if you go to the villages and all, or you have any kind of housing scheme, you need to have smaller areas of houses. People in the village cannot afford 200 square meters and leave your 3 meters setback. When you're planning, you need to plan from a particular perspective to at least see that the smaller houses and the poor people are able to also affordable housing is yes, because 75 square meters and 100 square meters with minimum. Yes. That's त्या तरेचे हावसिंग आतां आमच्या कॉन्स्टिट्युएन्सीन तुमी गेल्यार खंय इवन सीएमाच्या जर कॉन्स्टिट्युएन्सी तुमी खेडेगांवान भितर गेल्यार तो तुजे 200 स्क्वेअर मिटर 250 स्क्वेअर मिटर ताका परवडपाचें ना. That will be very expensive for him. So as a result of which, we have to see whether in a square meter, like in a 4,000 square meter plot, a certain amount of these type of structures with this type of a setback, which is minimum setback, which will benefit the common man, we are able to clear it. As a result of which this was introduced, because there is no clarity in the law. When you talk about inclusive housing, affordable housing, we only talk about, like Honorable CM was just mentioning, 20-point program, that has got a certain amount of relaxation. But generally, we need to see and figure it out, how do we provide relief to the common man? It is not only large projects. Every time we talk about a large project, every time in the assembly we discuss, but nobody ever talks about it. It is the Chief Minister who has supported this initiative of bringing this inclusive housing so that the small man is able to benefit. What Yuri, Honorable Leader of Opposition, is saying, he is talking to a specific project which has got a specific issue in that particular place, which I have assured him that I have already called for the file. Today I will have the file and I will be able to give him an outcome on that.
The Honorable Minister in the last assembly session had given us a word. I would like to tell the Honorable Home Minister, the Chief Minister, that if this project goes ahead, revolutionary, there will be a law and order situation there. तुई थिंग जायत पुसा येता तुवें मातशें हेजेर लक्ष घालचें आनी हें स्क्रॅप करचो.
Speaker sir, I want to add to this. I don't want to go to the legality of this project, but हांवूय कोंकळेचो आमगेलो Honorable Chief Minister भयणा थिंगा तिने सदां वयता because town planning minister गोळे पावल ना थिंगा. But as far as my knowledge, because I am also close, that has something that तो जागो मातशें भरपूर देवायलो त्या आजागे जाग म्हणटाय. And we don't want anything bad to happen to anyone. Actually, this is one very important point. Kitaku tinga mashe dewa bharpura. So it shouldn't be just. I don't know the technique, but this is the point what I know.
Speaker sir, एक issue हा. Inclusive affordable housing matter है. थोड्या हातूंत ताणें आतां दिला ते भशेन सेटबॅक इश्यू आसतात, सिंगल फॅमिली ड्वेलिंग. आतां फाल्यां बाब मोविन गुदीन म्हणूंक शकता आपले कॉन्स्टिट्युएन्सीन ते सिंगल फॅमिली ड्वेलिंगान काम जायना, ग्रावंड प्लस ती म्हळ्यार SRA करुया म्हणून. अशें SRA जर गांवांनी करूंक गेले जाल्यार द एथोज ऑफ द गोवन विलेजीस विल ऑल्सो बी irreparably damaged in certain villages, because you see that certain villages which have maintained their architectural aesthetics and the ethos of Goa, I have got value today. The others where massive development has happened have got finished. Many North Goa villages where ODPs have come have now become not very sellable. The ones which are low density, high cost is a model which has to be propagated in Goa. How do you give us a guarantee that this type of SRA units won't come up in under these guise?
No, we will, when we are prescribing the rules, we will make sure that this is specifically done in a particular manner. It has to be judiciously used. A law is brought in to make the provision to allow these things to happen. Like if you, in the villages today, if you go to see, my question is not only from the village point of view. If there is a large development that is taking place, in that large development also we can prescribe a certain section where a certain amount of plotting can be done for specific sizes and specific houses with specific setbacks. So when we talk about inclusive and affordable housing, that gives us only the flexibility to devise this type of a framework and policy. So as a result of which, I can assure you that this will be judiciously used and there will be no question of allowing these type of, because whatever, if you say that there is a 0.80 FSI in a particular place or 0.16 in a particular place, that all those factors will be taken into consideration and maintained. The whole idea is to create this type of affordable housing and to create inclusive housing. Inclusive housing was a word, that terminology that we use, so that to give us a flexibility. We can differ from project to project, but then we have to see that particular area. You have just mentioned, you just clarified that certain areas have been overexploited and used. We don't want to do that. But then we must also see that every section of society is integrated in when we are talking about planning.
Yes. No, only Speaker sir, rules jenna frame karta under the amendment. That time be careful about this. Because here you are only passing the amendment and you are bypassing other rules. So whilst making the new rules, this has to be considered.
We will consider.
Yes. Because a mantrin te answer mache teje dicha.
The Kunkulishe, I am file Magalia, and I will, I will give you, I have talked to CM has also said, I will take strict action in that matter. We will not proceed on that.
Yes. प्रश्न असो आसा विधेयक विचारून घेवचें जाका मान्य आसा ताणें अजून उरला.
So I stand to say that I do not agree to this bill number 4 of 2023. This bill proposes to empower the government to relax any provision of regulations framed under the said Act and allow implementation of government policies including inclusive housing and affordable housing. This bill is unlawful because the bill dilutes the existing provisions of law for protection of environment and hence violates the non-regression principle. Second, the government policies are general in nature and any change in land use or activity, even if destructive to nature, displacing local communities or unsustainable, can be included as required by the implementation of government policies. Therefore, this amendment will lead to large-scale corruption and nepotism. There is no need for this amendment as it is not clear how it was initiated and decided upon. This bill provides powers to the government to allow relaxation of any of the existing regulations, road access is necessary, setbacks, heights, FAR, etc., in the name of implementation of government policies. It is therefore completely not correct and purely for corruption by amending this. So when the law is being put, we have to make sure that all these considerations are taken and it does not make the environment impact when you are applying this law for this amendment.
Yes,
I would like to place this in the floor of the House.
Minister.
Sir, I request to move that the Bill 4/2023, the Goa Regulation of Land and Development Building Construction Amendment Bill 23 be passed.
Pass. हांव आतां विधेयक कलमगार सभाघरांत सादर करता. विधेयकांत दुरुस्त्यो नात. प्रश्न असो आसा कलम 2, कलम 1 अधिनियम सूत्र आनी प्रतीक मत्स्याचो विधेयकाचो भाग जावचें काय कितें? जाका मान्य आसा ताणें हय म्हणचें, जाका मान्य ना ताणें ना म्हणचें. हय मंडळाचे म्हणणे मान्य झाले. हय मंडळाचे म्हणणे मान्य झाले. कलम 2 कलम 1 अधिनियमन सूत्र आणि प्रदीर्घ मथळ्याचो विधेयकाचे भाग जाल्यात. शार आणि नगर नियोजन मंत्र्यांनी आता विधेयक मानून घेवपाचो प्रस्ताव मांडचो. मिनिस्टर.
I request that Bill number 4, 2023, the Goa Regulation and Land Development and Building Construction Amendment Bill 23 be passed.
Yes. प्रश्न असो आसा विधेयक मानून घेवचें. जाका मान्य आसा ताणें हय म्हणचें. जाका मान्य ना ताणें ना म्हणचें. हय म्हणटाचें म्हणणें मान्य जालां. हय म्हणटाचें म्हणणें मान्य जालां. गोंय जमीन विकास आनी इमारत बांदकाम नियमन दुरुस्ती विधेयक 2023 मान्य जालां. गोवा मूल्यवर्धित कर दुरुस्ती विधेयक 2023 मुख्यमंत्र्यांनी विधेयक विचारान घेवपाचो प्रस्ताव मांडचो. सीएम.
Sir, I request to move that the bill number 8 of 2023, the Goa Value Added Tax Amended Bill 2023 be taken into consideration.
प्रश्न असो आसा विधेयक विचारान घेवचें. जाका मान्य आसा ताणें हय म्हणचें. जाका मान्य आसा ताणें हय म्हणचें. जाका मान्य ना ताणें ना म्हणचें. हय म्हणटाचें म्हणणें मान्य जालां. हय म्हणटाचें म्हणणें मान्य जालां. विधेयक विचारान घेवपाचो प्रस्ताव मान्य जाला.
Sir, I requested to move that the bill number 8 of 2023 Goa Value Added.
एक मिनिट. हांव आतां विधेयक कलमगार सभाघरांत सादर करपाक विधेयकाची दुरुस्ती नात. प्रश्न असो आसा कलम 2 कलम 4 कलम 1 अधिनियमन सूत्र आणि प्रदीप मथळ्याचो विभागाचो भाग जावचो काय कितें. जाका मान्य आसा ताणें हय म्हणचें. जाका मान्य ना ताणें ना म्हणचें. हय म्हणटाचें म्हणणें मान्य जालां. हय म्हणटाचें म्हणणें मान्य जालां. कलम 2, 4 कलम 1 अधिनियमन सूत्र प्रदीप मथळ्याचो विधेयकाचे भाग जाला. चीफ मिनिस्टर मानून घेवपाचो प्रस्ताव मांडचो.
Sir, I requested to move that the bill number 8 of 2023 Goa Value Added Tax Amendment Bill 2023 be passed. Sir, a bill as a step towards the ease of doing the business. It is a requirement for the renewal of the registration certificate under the VAT Act, removed since 10th April 2017, and which was a long pending demand of the taxpayer, and after introduction of the GST to making the registration under the VAT, it is valid till cancelled. Yearly requirement of the renewal of the registration is being a long away with, and this will be bring the VAT structure in par with the GST law, as also encourage an upfront of the registration under the VAT Act. In order to keep the check on the fraudulent dealers, and it is a proposal to make the declaration of the PAN number, mobile number and email address in the registration application compulsory. Considering the hardship faced by the taxpayer during the pandemic, and it is a proposal to insert the new provision enabling the government to grant the benefits of the taxpayer for the COVID period, and to the extent and various time limits under the VAT Act. And the bill seeks to allow the refund to excess ITC determination on the account of the order of the authorities and which cannot be carried forward with the introduction of the GST.
Yes. प्रश्न असो आसा विधेयक मानून घेवचें. जाका मान्य आसा ताणें हय म्हणचें. जाका मान्य ना ताणें ना म्हणचें. हय म्हणटाचें म्हणणें मान्य जालें. हय म्हणटाचें म्हणणें मान्य जालें. गोंय मूल्यवर्धित कर दुरुस्ती विधेयक 2023 मान्य जाला. येस. आभार प्रस्तावाचेर मुखावली चर्चा चालू दवरची. कंटिन्युएशन. एक जस्ट 1 मिनिट. विरेश बोरकर हाणें आपल्यो दुरुस्ती मांडच्यो.
Speaker sir, I beg to move the following amendment to the motion of thanks to Governor's address as per list number 4.
दुरुस्त्यो सभागृहा मुखार आसात. जांकां उलोवपाचें आसा तांणी उलोवपाक हरकत ना. काल जें उरलां पण एक टायम काल ऑपोजिशन सायडीक कोण उरला तर कोणाक उलोवपाचें आसा. कोण उरला. एक एकटोच. मुख्यमंत्री सीएम सत्ताधारी कितलो टायम जाय. कोण उलयतले. कितलो टायम जाय. तुमकां कितलो टायम जाय.
स्पीकर सर, आमचे कोण उरला तेजे बटन मारतले आता.
1 वर.
तेवटेंच्यान कोण उरला.
बाब तुका ऑपोजिशन सायडीक
विरेश दोगूच जाण उरल्या. 6:30.
1 वर. आमकां बाय 8:30 पर्यंत सोंपपाक जाता.
1 वर लागतलें. स्पीकर सर, हांव काल उलोवपा आसलो. तुमी सांगलें आज रावला.
वोटिंग आसा
विरेश
परत येवपा जाय
विरेश भाऊ
स्पीकर सर आमकां एक वर
आमकां
तुमकां एक वर कित्याक रे दोगूच जाणां मरे
काल उलोवपा
अर्दे वर
काल उरले मरे
आमी अर्दे वर
Can I speak yesterday?
हाफ एन अवर
I will speak.
तांकां दोगांयकूय मेळून पावण वर
हय
45 मिनिट
45 मिनिट्स
एक और हांव मागीर उलयता आसतना
सुरू कर
कोण
स्पीकर सर विदाउट वेस्टिंग टायम
आं
पयलो
चल विरेश बोरकर येस
I raised to Speaker sir, I raised to support the amendment moved in list number 4. Speaker sir, गव्हर्नराच्या एड्रेसान पयलू म्हणजे घेवंक सोदता ते म्हणजे गव्हर्नराच्या एड्रेसान म्हादयचो जो विशय आसा तो म्हादयचो विशय घेतलोच ना. आमकां खूब दूख दिसता, आमकां ब्लॅक डे कसो दिसता, कारण येद्या व्हडल्या गव्हर्नराचे स्पीच जी आसा ते गव्हर्नराचे स्पीचीन म्हादयचो विशय मांडलोच ना. मात कर्नाटकाच्या विधानसभेन जो कर्नाटकाचो गव्हर्नराची स्पीच आसा 2018ची त्या स्पीचीन तेंच्यांनी मेन्शन केला म्हादयचो जो विशय आसा तो तेंच्यांनी मांडला. आयज खरेंच गव्हर्नरान मेन्शन करपाक जाय आसलें, कित्याक म्हादयचो इश्यू गोंयांत वाडत चल्लेलो आसा आनी चड जाल्लो आसा, मात सरकाराक तेजे पडलेलेच ना. हें ह्या अंदूच्या गव्हर्नराच्या स्पीचीन दिसता. तशेंच कर्नाटकाच्या सरकारान बजेट जो स्पीच आसा तितूनय 2022च्या तितूनय म्हादयचो इश्यू मेन्शन केल्लो. मात आमचो गोंय सरकार कितलो सिरियस आसा हें म्हाका खबर ना. फुडें पळोवंक गेल्यार गोंयची जी क्रायम रेट आसा, आयज तुमी पळयता आसतले हांगा क्रायम डिटेक्शन रेट सांगलेली आसा 84%, पूण क्रायम प्रिव्हेन्शन रेट ही सरकारान कांयच सांगलेली ना, मेन्शनूच केल्ली ना. आयज तुमी पळयता सगळे कडेन न्यूज पेपरार एवरी डे क्रायम्स येता, पण क्रायम कसो प्रिव्हेंट करपाचो हें आजून पर्यंत सरकारान हेजेर मेन्शन केल्लें ना. गव्हर्नर स्पीचीर कांयच मेन्शन केल्लें ना. आयज तुमी पळयता आसतले स्लम्स वाडत चल्लेले आसा, इनलिगलिटीज वाडत चल्लेले आसा, स्क्रॅपी यार्ड्स वाडत चल्लेले आसा. आयज जाय तशे मशरूम जाय इनलिगलिटी मशरूम जायत आसा, मात सरकाराचो एक्शन प्लॅन जो समज मायग्रंट व्हेरिफिकेशन जे आसा तेंच्या नेटीव प्लेसीच्यान म्हटल्यार तेंच्या स्टेटींच्यान ते जावपाक जाय तें मेन्शन केल्लें ना. सो म्हाका खूब दूख दिसता, कारण सरकार हें सिरियसली घेयना. तशेंच इंटरस्टेट मायग्रंट वर्कमॅन एक्ट हो जो आसा तेजी डॉक्युमेंटेशन केल्या काय ना हें कांयच मेन्शन केल्लें ना ह्या गव्हर्नर स्पीचीन. जेन्ना आमी फुडें पळयता आमचे एक्सिडंट्स आयज गोंयभरांत तुमी पळयता आसतले कितलेशे एक्सिडंट जायत आसा, मात तेजी प्रिव्हेन्शन आमच्या PWD डिपार्टमेंटान हेजेर कांयच मेन्शन केल्लें ना की प्रिव्हेंट करपा लागून एक्सिडंट प्रिव्हेंट करपा लागून कितें करता. इयरली ऑडिट एक्सिडंट जाल्या कितले, इयरली ऑडिट केला काय ना हें कांयच मेन्शन केल्लें ना ह्या जे गव्हर्नर स्पीचीन. एक्सिडंट डिक्रीज करपाक आमी कितें स्टेप्स घेतले, अवेरनस कितें केल्या, जावं फुडें आमी कितें स्टेप्स घेतले हेजो एक्शन प्लॅन रिपोर्ट जावं हेजेर कांय मेन्शन केल्लो ना. रस्त्याची आयज तुमी पळयता आसतले प्रत्येक कडेन रस्ते डेंजरस जाल्ले आसा, रोड इंजिनियरींग फेलियर जाल्लो आसा. आयज गोंयांत तुमी पळयता जेन्ना आमी रस्ते वयता आयज मेन रोड आमचो जो हायवे आसा NH66 हो हायवे इतलो डेंजर जाल्लो आसा, खंयच्यान वचपाचें ना हें कांयच कळना. आमच्या हायवेंचेर आयज ओव्हरब्रीज जावपाक जाय आसले, जो डिझायन जावपाक जाय आसलो ओव्हरब्रीज अंडरपास, खूब कडेन ओव्हरब्रीज अंडरपास सारकें ना. उदकाचो जो फ्लो आसा तो फ्लो खंयच्यान वचपाचो ते सारकें ना. आमी ऑलरेडी मिनिस्टरांकूय सांगला, पण आजून पर्यंत तेजो न्याय मेळोंक ना. खंयच्यान एक्शन प्लॅन कितें आसा, फुडलो एक्शन प्लॅन कितें आसा तो आजून पर्यंत सरकारान हेजेर मेन्शन केल्लोच ना. फुडें आमी जेन्ना पळयता फायर डिपार्टमेंट आयज खरेंच जेन्ना पिलेन इंडस्ट्रियल स्टेटीन उजो लागलो फायर फायटर्स थंय धांवून येयले, पण सरकाराचो हेजेर प्लॅन कांय ना. कशें आमी फायर प्रोटेक्शन करतले जावं प्रिव्हेन्शन करतले. जेन्ना उजो लागता तो उजो कसो प्रिव्हेन्शन करतले, फुडें हेल्था कडेन हेल्थाक प्रोविजन कितें आसा तें मेन्शन केल्लें ना. आयज तुमी पळयता खंयच्याच जे इंडस्ट्री आसा तो ऑडिट टायम टू टायम जाता काय ना हें ह्या स्पिचीन मेन्शन केल्लें ना. ऑडिट रिपोर्ट्स कांय ना. सो आमचो सरकार जो आसा तो अपयशी ठरलेलो आसा हें ऑडिट करपाक जावं ऑडिट मेन्शन्स करपाक. आमी पळयता उजो कंटिन्युअसली लागत आसा. आयज लास्ट टायम कोलवाळे येदो व्हडलो स्क्रॅप यार्ड तो इनलिगल स्क्रॅप यार्ड आसा. सरकार तांकां कशी प्रोविजन दिता, सरकार कित्याक एक्शन घेयना म्हाका खबर ना. कोणाची कितें सेटिंग्स आसा ती म्हाका खबर ना. मात एक्शन ही हेंचेर जायत ना. आमी कितल्योश्यो कंप्लेनी घातल्यो मात तेंचेर एक्शन जायना. तशेंच म्हापसावी असोच उजो लागलो, तेजें कितें फुडें जालें तें कांयच खबर ना. आयज पिल्यान उजो लागला, पिल्यानूय कितें जातलें तें कांय खबर ना. कॉम्पन्सेशन मेळटलें काय ना, रेक्टिफाय करतले काय ना हें कांय खबर ना. इंडस्ट्रीज ज्यो इंडस्ट्रीन आसा तांकां प्रॉपर ट्रेनिंग मेळटली, प्रॉपर ट्रेनिंग मेळटा हेंय कोणाक कांय खबर ना. हेजेर कांयच मेन्शन केल्लें ना. जेन्ना आमी पळयता आमचो आयज टॅक्स पेयराचो पयसो इनवॉल्व जाता, आमचे फायर फायटर थंय वयता, तांकां कितलेशे उदक यूज करचें पडटा, आमचे ग्रावंड वॉटर खंय ना खंय पोल्यूट जाता. हो जो ग्रावंड वॉटर पोल्यूट जाता हेजो हार्मफूल इफेक्ट सगळ्या लोकांक जाता. सो हेजेर सरकारान दखल घेतल्या काय ना हेजेर कांयच मेन्शन केल्लें ना की कितें एक्शन घेतलें, कितें जो आतांच इन्सिडंट जाला त्या इन्सिडंटाचेर कितें एक्शन घेतलें तें गव्हर्नर स्पिचीन कांयच मेन्शन केल्लें ना. आमी जेन्ना सेफ्टी आमची पळयता आयज प्रत्येक कडेन सेफ अशें आमकां दिसना. जेन्ना सरकार म्हणटा की आमी सगळे कडेन क्रायम डिटेक्शन डिटेक्ट करता, प्रिव्हेन्शन जायना, पण स्क्रॅप यार्डां जावं स्लम्स जी आसा आयज थंय ट्रॅकिंग जायना की बाबा हांगा एक्शन कितें जाला, हो पुलीस फोर्सान एक्शन घेवपाक जाय, होम डिपार्टमेंटान प्रॉपर एक्शन घेवपाक जाय, हें कांयच मेन्शन केल्लें ना. फुडें आमी जेन्ना वयता तेन्ना एग्रीकल्चर डिपार्टमेंट, जेन्ना एग्रीकल्चराचें आमी उलयता आयज आमी डिमांड केल्लो आसा की खाजन जी शेती आसा हेजेर कांयच मेन्शन केल्लें ना की रिवायवल ऑफ खाजन लँड जे आमी रिवायव करपाक सोदता. सरकार खरेंच सिरियस आसा काय कितें काय बेश्टोच सांगता की आमी शेतकारांक वयर काडपाक सोदता, शेतकारांक ही स्कीम दिता ती स्कीम दिता. खरेंच आमी प्रोटेक्ट करूंक सोदता काय कितें शेतकारांक, काय ह्यो ज्यो आमच्यो जमनी आसा त्यो पडींग पडटा तांकां काबार करपाक सोदता, त्यो स्लम हाडपाक सोदता, जावं तेजेर इनलिगलिटी हाडपाक सोदता. सरकारान हेजेर कांयच प्लॅन केल्लो ना, कांयच सांगलेलें ना, हेजेर दाखोवनूच दिल्लें ना की एक्शन प्लॅन कितें आसा सरकाराचो. आमी मागलेली आसा 10,000 करोडाची पॅकेज खाजन रिवायवलाक लागून सेंट्रल गव्हर्मेंटा कडेन, ती सरकारान घेवची, हितून घालची की आमी पॅकेज मागता म्हणून. कारण कितलेशा हजारांनी हेक्टर जमीन आसा खाजनाची आनी फक्त आमच्या मतदारांक न्हू प्रत्येक मतदारसंघात केदी व्हडली शेती आसा मात ती शेतीक रिवायवल करपाक लागून आजून पर्यंत एक मेजर स्टेप घेतलेलो ना. सो हांव मागता सरकारा कडेन की तुमी एक्शन प्लॅन करचो, रिवायवल ऑफ खाजन लँड ही पॅकेज हाडची, मागची, डिमांड करची. कारण जेन्ना पर्यंत ही पॅकेज घालिना आमचे जे बांद आसा आमकां वॉटर फ्लोज आसा त्यो प्रोवायड सारक्यो करपाक जाय. आयज त्या बांदांची हायट वाडोवपाक जाय. हेजेर